All mention memos given.
Here. Wait, please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 52, your lordship.
52?
Lordship.
Why?
Lordship, 2 weeks time may be given to file my affidavit, lordship.
I have some urgency because my petitioner is not getting anything. It's a third round of litigation.
Lordship, first time it has come. Can it be fixed on 5th of
After
August?
returnable date, after notice.
Let it come on 5th of August, my lord.
You want to file an EOFO for appeal respondent?
2 to 5, lordship.
Your name?
W. Sharma, lordship.
Sir W. Sharma, learned counsel for the respondent number 2 to 5 submits that we be granted fixed time to file an affidavit on behalf of the respondents represent. I accepted registry to list this matter again on 5/8/2026. So the petition respondent shall file or bring on record their stand by way of filing an affidavit on or before 31/7/2026.
Obliged, lordship.
May I please your lordship? Lordship, item number 15. Lordship, matter may be adjourned for a week.
50?
15. 1-5. Lordship, NJ Gogoi is out of station due to some medical emergency of his family. Lordship, letter of absence is filed and it is shown in supplementary list also.
Who is absent?
NJ Gogoi. Letter of absence is filed.
A prayer is made on behalf of Mr. NJ counsel petitioner for an adjournment in the matter on the prayer accepted a registry to list this matter again on when?
Lordship, after 24.
Huh?
After 24, Lordship.
After
24.
22.
24/7, Lordship. After
24/7. On 27.
Obliged.
The consent of the other side, my lord. I beg to mention item number 54. We have received our instruction, my lord. File affidavit in opposition. My lordship may allow 10 days time.
The prayer of Miss A. Bora, learned standing counsel NHN.
Yes, my lord.
You have taken the consent.
Yes, your lordship. I'm the petitioner.
Stands adjourned for 2 weeks. Facilitate filing of affidavit by the respondents.
Wait, date.
Registry to list this matter again. 2 weeks you get it?
Lordship, there is an urgency that is why.
2026 matter.
Lordship, the petitioner has been debarred from service, your lordship, without filing any charge sheet. No disciplinary action has been taken, your lordship. That's why there is an urgency. Since 2024, he is debarred.
Registry to list this matter again on 10/8/2020. You file your affidavits with.
Yes.
Obliged, your lordship.
May I please, your lordship. With the consent of the other side, back to mention item number 37, lordship. Adjournment slip has been circulated, lordship.
Readings are complete.
Yes, lordship.
But I am appearing for 37, my lord.
Any problem today?
Today he has got some difficulty. There is urgency on my part, my lord. Can it be on next Thursday or Friday?
I can at best accommodate you on 28.
28.
So 47 matters because of
37, 47, 48.
47, 48. In these two matters, Lordship, I am for the petition. My recruitment result has been stalled because of the order passed in this case. So urgency is there, Lordship. So if Lordship
Okay, when?
reaches to
29th, my lord.
on 24,
Also 23rd, if it is.
23rd, my lord.
Who does it? We'll be just waiting.
Thursday, Lordship.
Can we have it on 8 would be
29th, if it is not incoming.
29th. Okay.
29th, my lord.
Because if that series matters are there on that day.
Lordship.
Regular, if that goes, I'll have time. Item number 37.
47 and
47 and 48. Huh? 47, 48. On the prayer of the learned counsel for the parties, registry to discuss this matter again on 29/7/2026.
Deeply obliged.
May I please, lordship? I beg to mention, my lord, item 59, the contempt matter. In this case, my lord, they have complied with, my lord, but the payment is not made yet. It's under process. So
What
it
do
may,
you want?
it may come after 2 weeks, my lord. By this
On the
time,
prayer
back
of
in
Mr. Item number?
59, my lord.
On the prayer of Mr. B. Proceedings, registry to list this matter again after 2 weeks.
Any date may be given after. Obliged, lordship.
The order is being complied with.
Order is complied. The process is payment is only back.
It is, your lordship. I am praying for my lord tagging of a fresh contempt case with my lord today's item 50 in court 19, my lord. Our interim order has been violated, my lord. A petitioner was protected from transfer because she is the mother of
Item number?
a 50 at court 19, my lord.
Done.
Yes.
You want it today itself?
Today, my lord, with the item, my lord, item 50.
Would you rather be? But no. Yes,
Apply.
yes, ma'am.
May it please your lordship, I beg to mention a list of cases for urgent listing.
Is the urgency, ma'am?
Urgency is that is notice issued on 20th of April, and 4 weeks time have been granted, but returnable time is over.
You give it to you.
That's
Lordship, I beg to mention item number 66, Lordship. In that item, we have filed an additional affidavit, Lordship. Same is not on record. That may be called for, your Lordship.
You have challenged the
Disciplinary
department
procedure.
that there was some clarification sought.
Lordship sought for information on one
There are
document
two charge sheets,
Your Lordship,
two show causes.
that we have brought on record.
May I please, your lordship? I beg to mention item number 11, my lord. This matter, my lord, earlier listed on motion status. Today also listed on motion status. Earlier listed on motion status, my lord, on 5th June 2026. Today also listed on motion status, my lord. And
We'll consider what is that? Any bar? No bar.
No.
You are a grade 4 employee. You have not been paid. You got to show me what is your right. We'll see. We'll ask them.
May I please, your lordship, I beg to mention for listing lordship in admission.
Mr. M.A. I have to say, the petitioner. The petitioner in the present contempt petition has alleged violation of the directions passed by this order dated 22/8/2025 in WPC number 2565/2024 to notice returnable 4 weeks. Petitioner to take steps for service of notice upon the respondents by way of registered post steps within 2 working days from today. 3 working days. The personal appearance of the respondents are dispensed with at this stage. Registry to list this matter up 4 weeks on a date. Ms. Ardeka. Yes.
Lordship, his contempt petition is for non-compliance of honorable court order dated lordship 28/5/25, lordship. And relevant part is at para 7, page 20.
That encadrement you are now asking, but you are all personal posts.
Yes,
How
lordship.
can that be encadred?
Lordship, it is, there's a direction for honorable court order as per division bench order, lordship.
They have done it for the assistant engineers, for junior engineer to assistant engineer, but they are not doing it for grade 4 people.
Yes, lordship.
But Ms. Ardeka, learned council. Parveena Bagi? Order dated 28/5/22 in WPC number 18420. Respondents.
Public.
What if I kindly peruse the last order for a moment? Wherein the
Madam, what is your advance exactly?
Lordships, it is against the impugned suspension order. The second suspension, the extension of the suspension has been made without recording any reasons. The Lordships are aware of the law in this regard. That is my simple case before this honorable court. There is actually no requirement of any affidavit. However, in terms of this thing, an opportunity to be given to the university, they have already taken on three occasions, your Lordships. This will be the third occasion. And if your Lordship will kindly peruse the last order, it very
seen.
categorically said that
Where is your second order of
suspension, Lordships will find it. The second order of suspension is 17/3/2026, which is at page 56, your Lordships.
When was the show cause issued to you?
Show cause was issued on.
This is an extension of
17th
order of suspension.
The same day, Your Lordships. On the same day, 17/3/2026, the memo.
No,
Yes, Your
madam, this is an extension of the earlier order of
Yes,
suspension.
yes. The first suspension was 18/12/2025. That Your Lordships will find at page 42.
And on 17/3, they
Yes.
have given you a show cause.
Show cause, and on the same day, they have also extended the suspension, but without any
Okay.
reasons.
So this show cause is within 3 months.
On that day,
That day.
yes, on that
Fine,
day.
that
yes.
is on 3 months.
Yes, 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 Your Lordship.
Yes, madam.
Lordship, certain new developments have taken place in the
Forget your
matter.
new developments. What about the old developments? What is the reason assigned for requiring cognation of his suspension? What is the reason? That's all.
Lordship may refer to the executive council meeting held on 16th March, page 58, Your Lordship.
Yeah.
The relevant portion will be in page 59, Your Lordship. Since the preliminary inquiry in the charge sheet had been drafted, so for further proceedings, the suspension was
Madam,
extended.
this is in violation of the 3 lines, first 3 lines of para 21 of Ajay Chaudhary. This is not a situation which has been contemplated herein post issuance of a show cause notice. This is pre-issuance of a show cause. If you read the 3 lines of Ajay Chaudhary, para 21, we can come to para 21. That penultimate paragraph. Can you read it loudly so I also can recollect?
Lordship, there's no para number 21 here.
No, not para. You just read the penultimate paragraph. That's all. Last but one paragraph.
Yes. Para number 14 here. We therefore direct that the currency of a suspension order should not extend beyond 3 months if within this period the memorandum of charges / charge sheet is not served on the delinquent officer or employee. If the memorandum of charges or charge sheet is served,
Is served.
a reasoned order
Where is that?
must be passed.
So this resolution is only an approval given to the show cause. Where is the resolution of the EC extending the suspension?
Lordship, that we will clear our stand in the affidavit if a last
Sorry.
opportunity is
You
afforded.
have been taking time after time. Why? You
Lordship,
are any special entity?
no, Lordship, it was the disciplinary proceedings were about to start. However,
Forget the disciplinary proceeding. Why go into unnecessary aspects? We are on the point as to whether after issuance of the charge sheet, any decision was taken to extend the proximate to the time when the charge sheet was served on. And it's a settled position of law.
Yes, sir.
If that is not there, the order of suspension goes. Ms. Chaudhary, other than this 58 and 59, there is nothing?
There is nothing in it.
When?
Lordship will file by next week, Lordship.
No.
Monday, Tuesday, by Tuesday we'll file, Lordship.
We are disposing of this matter on Wednesday. Do whatever you want to. Right?
Yes, sir.
Yes, Your Lordship.
How did you issue this order then at page 56? Subject to ratification. Cannot. Second paragraph, subject to ratification. That means there is nothing. But Ms. R. Chaudhary, learned counsel appearing for the petitioner. So heard Ms. P. Learned standing learned counsel appearing for the Assam University and Dr. P. Agarwal, learned standing counsel. GC. Ms. Chaudhary has submitted that the order dated 17/3/2020 has admittedly been so passed in clear violation of the decision of the Honorable Supreme Court in the case of Ajay Kumar,
2015, 7 SSC
2015, 7 SSC 29.
91.
He submits that there is no decision taken by the competent authority of the university to continue to place the petitioner under suspension after a departmental proceeding was instituted against him by issuance of a, it's called a memorandum of charge,
Yes, Your Honor.
by issuance of a memorandum of charge dated 17/3/2026. SP Upadhyay submits that although the affidavit has not been filed, she would complete her instructions and apprise the court on the basis of passing of the impugned order dated 17/2026, continuing the suspension of the petitioner. Also, as a last opportunity, the matter, in view of the submissions made by Ms. P. Upadhyay, a last opportunity is granted to her to complete her instructions in the matter. Registry to list this matter again on 22/7/2026.
Lordship.
We'll dispose it off on that.
Lordship. Lordship, could it be on 23rd?
23rd, no problem.
23rd, deeply obliged. Ma'am, bolu.
Yes, who is for the health?
Lordship, here I am appearing for the help.
Yes, what happened?
Lordship, the period for which my learned friend is asking for the salary, Lordship, the petitioner was absent. There was unauthorized absence on the part of the.
Have you declared that?
Lordship, I can file my affidavit, Lordship. We have the necessary documents to place that on.
We are not issuing a notice, you file your.
That's Lordship.
Mr. A. Chalia, Learned Standing Counsel, Health Department submits that he has received his instructions and would file an affidavit in the matter on or before,
Lordship, 3 weeks, Lordship, within 3 weeks.
on or before 7/8/2026. Registry to list this matter again on 14/8/2026. Which is said affidavit.
May I please the Lordship, pass over the matter for time. Lordship, in this case, we have received the area SLI proposal from the inspector, but there is some discrepancy. That's why I have directed him to resubmit the same again, Lordship. I'll pass over the matter.
It takes you more than 2 months to examine this proposal in your establishment.
Hello, Chief.
Proposal was received on 24/4. The claim is of 22. What was happening in between?
Let that, I will ask them to expedite the matter from the jurisdictional inspector next date, Lordship.
Yes, what do you have?
Pass over the matter for timing. My senior is on the way.
Who is your senior?
HR Chaudhary.
Yeah, we'll not trouble Mr. HR Chaudhary. Mr. Dotto has given us some instructions. We'll ask him to expedite the matter. Next date, we'll see. We'll keep it for motions only. Mr. PP Dotto, Learned Standing Counsel, Department of School Education, on instructions has submitted that the area salary proposal received from the jurisdictional inspector of schools was examined in the Directorate of Secondary Education, and it was found that there were certain discrepancies existing there. Accordingly, the said proposal has been remanded back to the jurisdictional inspector of schools for rectification. He submits that a rectification proposal would be submitted in the matter expeditiously by the inspector of schools, and by the next date of listing, the matter would be processed for placing before the government for its approval.
That's it.
Also, accordingly, he prays that the matter be taken up on
After 8 weeks, Lordship.
reasonable on
For date, my lord.
documentary on 19/8/2026, on which date he shall place the documents before this court envisaging placement of the proposal before the government for approval. A copy of the Communication dated 10/7/2026 furnished by Mr. Toto is kept on record and marked as X for the purpose of.
May it please your lordship. May the petitioners before your lordships are appointed by the respective hospital management society.
Yes, what is your instruction?
Lordship, here, we need some time to obtain our instruction.
Why?
Lordship. Lordship, here,
See, the thing is, you had initiated an exercise for collecting information.
Lordship.
Their only prayer is that, what I can discern is that their particulars have to be sent.
Yes,
Have
Lordship.
you sent it or not?
Yes,
That's all.
Lordship, here there was an exercise taken by the government from all administrative departments to collect the names. Whether their names have been forwarded or not, and
Absolutely.
Lordship, that is, Lordship may grant me some time, Lordship, we have already communicated to the department.
Otherwise, the matter is covered by your lordship's judgment, my lord. Lord, if
Lordship will
president dispose of
yes.
in that term.
No, Lordship will
I
grant us.
want to ensure that it has.
Yes, Lordship, that is why.
Ensure that.
Lordship will grant
Otherwise,
us
Mr.
2 weeks.
Dekar, tomorrow there will be innumerable problems. Mr. Cholia, Learned Standing Council,
Health Department.
Health Department, submits that he would apprise this court as to whether the names of the petitioners have been forwarded by the district level authorities for consideration of their respective cases, for authorizing to them the minimum scale of pay as authorized to a similar post in the regular cadre. Also, this court accordingly, in view of the above submission of Mr. Chalia, this court adjourns the matter today and directs the registry to list this matter on 24/7/2026. By the next 27/7/2026. By the next date of listing, Mr. Cholia shall place on record written instructions are received from the competent authority with regard to the query of this court as to whether the names of the petitioners along with their service particulars have been forwarded to the Directorate of Health Services, Assam, for consideration of their respective cases for authorization of their wages at the minimum scale of pay prescribed for the equivalent post in the regular cadre. Once that comes, we will discuss. Otherwise, Mr. Dega creates problem.
Lordship. My lord, can it on 29th?
No problem. 29.
Lordship. Big problem.
May I please your lordship? My lord, the petition was HBP for us.
What about the delay, Mr.
My lord, I was when I was taken my earn leave, then I go to the went to the my lord. I give the representation annex 12. The copy
Page,
that
page,
3/5/2024.
24, but your order is of 2018.
2018, I do not know. This order is not communicated to me, my lord. My lord, kindly see. Kindly see, my lord. Para 9. Para 9, page 12, my lord. Or annexer 15, page 65 to 66, my lord.
Huh?
Para 9, page 12 of the deed petition.
No, I got it. But from the date you were absent, have you informed you or your family members informed the authorities that because of these reasons, I am not in a position to upload? Have you informed?
It is kind, my lord. They are not in a position to say.
Where is that material to understand, to determine that? Where is your medical certificates?
A medical certificate. My medical certificate is, my lord. Page annexes 7 and 8. Page 33 to 38 and annexes 6 and 7. Annexer 6 and 7,
33.
33. The copy of copy of medical certificate dated 39. 39.
You were unauthorizedly absent since when?
Due to my medical treatment, my lord, I am a
Okay, when,
Secretary.
from when?
uh,
Where is the show cause? Memorandum of charge? Are you sure?
my lord, after giving
Are you
representation,
sure? Is the memorandum of charge?
A memorandum of suspense.
Heard Mr. A. Das, learned for the petition. Also heard Mr. S.K. Medi, learned, learned CBC appearing for all the response. The petitioner in the present writ, by way of instituting the present writ, has essayed an order dated 6/4/2018. Page, order is that page?
order
Page?
by 1/17/18. Page. My lord, page 1/17/18. 1/18.
Removing him from his services. Issue notice, a returnable oath. Mr. S.K. Medi, learned counsel for the petition, or learned CGC accepts notice on behalf of all the respondents. So, the issue of maintainability of the present writ petition, however, is kept open to be urged by the learned counsel for the respondents on the next returnable date.
My lord, there is a small mistake in page 117, dead mistake, and page 16. Same petition, dead mistake. May I correct?
It's a motion, that's why I did not dismiss it. Otherwise, I would have dismissed it. You file an additional affidavit to.
Huh?
Additional affidavit to that.
National Assembly. Okay. Oblige, my lord.
Senior counsel AR, we will do this matter. He is on legs in another courtroom. And pass over for a time being.
Ms. Borua, find out one thing. Whether there is a limitation period of validity of a select list for Gauhati.
Yes.
There is a period of validity of a select list for Gauhati. Then it can, if there is a select list, it will be for eternity.
But rules for 1 year is the validity. After that, it cannot be continued.
Call him, let him come.
Please, Your Lordship. Lordship, this is the case regarding minimum pay scale and regularization of service, my lord.
Yes, why are you not paying them their salaries?
Lordship, first of all, they are engaged by Hospital Management Society.
Yes.
And Hospital Management Society is not the party here. So.
Legal aid, what she will know. Can you take some instructions?
Yes, Lordship, I'll take instruction, but party is necessary because.
Legal aid matter. Legal aid matter. This is legal aid. Not
Yes,
the
Lord.
petitioner. So we deem it that it is there. When you are there, everything is there. You are also overpowering.
Notice ways.
No notices. Standing Council, Health and Family Welfare Department.
Yes, Lord.
Submits that she be granted 2 weeks time to complete her instructions in the matter. Pray accepted, registry to list this matter again on 3/8/2026. Just get it.
3/8, yeah.
Because there are communications from your departmental authorities. Also.
Yes, Lordship, but the Hospital Management Society is a different body.
Because they collect the money from the patients and all, whatever, charge, then they make that payment.
Yes.
If you go through the writ petition, there are documents issued by deputy director,
Yes.
superintendent. Just see what.
Yes, but yes, Lordship, I'll take instruction.
Petitioner in person, Lordship.
We'll wait for some time. Fine of rupees 51,000. Upheld again.
Regarding the initiation of de novo proceeding, he has already approached the Honorable Rajasthan High Court, Lordship. That case is pending.
Why there, then why this here?
That's why.
No. How
Yes.
did he appear before the Rajasthan High Court?
I think that time he was posted at Rajasthan High Court.
Oh, yes. Yes, Mr. Sharma. Next matter.
Hello. Hello.
Yes, yes.
Good morning, sir. This is Amit Kumar Sharma. This is case number.
Yes, please go
item
ahead.
number 18, na? Yes, sir.
Please
Hello.
go ahead. Please go
Sir,
ahead.
yes, sir. Sir, in short, my matter is that in 2022, a disciplinary inquiry was initiated against me, and subsequently, I was given a major punishment. And sir, in December 2022, this disciplinary inquiry was quashed because of violation of principles of natural justice.
Your presently an order of dismissal was issued to you on 15/6/2023, 23. Against that, you preferred an appeal. That appeal was rejected on
No, sir, dates are wrong.
6/12/25, right?
Sir, that appeal was rejected on, sir, 16/12/2024.
6/12/24.
24. Yes, yes.
So we'll have to examine. Today we can't do nothing. We'll just issue a notice today.
Yeah, yes, sir. I want you to please issue the notice to the respondents. Yes, sir.
That's
Sir, I have exhausted my all the options.
Petitioner in person. Also
Yes.
heard Mr. K. Kolisa, Learned Standing Council, Oil India Limited. The petitioner in the present, by way of instituting the present or petition, has presented a challenge to an order dated 16/12/2024. No,
Yes, sir, it is right. It is 16/12/2024.
5/9/2024, passed by the disciplinary authority, imposing a penalty of recovery of a penalty of fine of rupees 51,000 upon the petitioner on conclusion of a departmental proceeding instituted against him. The petitioner has also assailed an order dated 16/12/2024, passed by the appellate authority, rejecting the appeal of the petitioner and thereby affirming the penalty imposed upon him by the disciplinary authority. Issue notice, returnable 6 weeks. Mr. Kolita accepts notice on behalf of all the respondents.
Lordship may not record as a standing counsel, Lordship.
Mr. K. Kolita, Learned Counsel, accepts notice on behalf of all the respondents. Court of Standing Counsel. Registry to list this matter again on Seven 9/2026.
Hello.
7/9, Mr. Sharma.
Okay.
That's within 3 working days. You supply the requisite extra copies within 3 working days from today.
Okay, sir.
Mr. Roy, I can't take up this matter. Petition number 3 is very known to me. Registry to list this matter before any other bench without me. We studied law together. We studied law together. Senior to me, I call him Dada, but we studied law together.
Lordship, petitioner before your lordship for the dismissal order dated 15/06/2023, lordship. Annexure 1, page 34.
But Mr. J.K. Goswami, learned counsel, it's rare that we get Mr. Goswami this side.
On the other side.
No,
Lordship,
no,
one
no
thing I would
further
like to
ado,
point out,
we are issuing notice.
One aspect of the matter, the name of the bank is, since October 2025, it's changed. Now it's not Assam Gramin Vikas Bank, it is only Assam Gramin Bank. Gazette
We will take
notification,
necessary steps.
that correction may be done.
You file an amended copy.
Lordship.
So and Mr. A. Ganguly, learned counsel representing the Assam Gramin Bank authorities. Mr. Ganguly at the outset has submitted that the name of the respondent number 1 bank is presently Assam Gramin Bank and not Assam Gramin Vikas Bank. Mr. J.K. Goswami submits that he would file an amended cost title rectifying the name of the respondent bank within 2 working days from today. Also, issue notice returnable 4 weeks. Mr. Ganguly accepts notice on behalf of all the respondents. No formal notice, requisite extra copies, so and so. Registered to list this matter again after 4 weeks on a date to which.
Lords.
Wait, please, my lord. My lord, the petition.
Your grievance.
Lordship, actually, my grievance is that I should be promoted to the post of Anganwadi.
That is a genuine grievance. But why writ petition?
Actually,
If you
Lordship,
qualify, you get it.
actually, Lordship, I'm the only qualified candidate.
You say that respondent number 4 or 5.
Yes,
whoever
Lord,
it's,
yes.
she is above 50.
She is above 50. And before this, there is another writ petition pending.
That is with regard to direct recruitment.
Yes.
This is promotion.
No, that was also promotional. That was also.
That was direct recruitment. Come to page 3022.
Yes, Lordship.
This is direct recruitment.
Now, in page 23, Lordship, actually.
This is direct recruitment, it is 45.
Yes.
And now presently, 5/6/2026 48.
Yes.
This is promotion. That same village, 50 years. We'll see.
Yes.
We'll issue a notice.
Yes.
And it will be subject to outcome of the case. But Mr.
M.K. Chaudhary.
M.K. Chaudhary, learned counsel for the also heard Ms. S. Borua, learned government advocate. The petitioner in the present petition has prayed for a direction for cancellation of the candidature of the respondent number 3 for recruitment for promotion to the post of Anganwadi worker in pursuance to the process of recruitment initiated by advertisement dated 5/6/2026. So it is submitted by the petitioner that the respondent number 3 has exceeded the age of 50 years on the last date fixed for submission of applications in the advertisement dated 5/6/2026. So issue notice returnable 4 weeks. Ms. S. Borua accepts notice on behalf of the respondents number 1, 2, 3, 1, 2, and 3.
1, 2, 3.
1 plus 3. Actually, Lordship, that 3 should have been 4. The private respondent is 4.
4, 4. 3. No, ठीक है. 1, 2, 3, 4. ठीक है. 1, 2, 3. 8 ऊपर 2 रहे तो 4 को डिवाइड. No formal notice. Petitioner to take steps for service of is upon respondent number 4 by way of speed post. Steps within 3 working days from today. Also, it is provided that the recruitment in pursuant selection and appointment effected in pursuant to the advertisement dated 31/5/2025 against the post of Anganwadi worker in Dokhin
Somoka.
Tomoka, huh?
Somoka. Yes.
Anganwadi Center shall be subject to the outcome of the present registry to list this matter after 4 weeks.
Lordship, I think the earlier advertisement is mentioned. It should be 5/6/20.
Oh, sorry, 5/6/20. 5/6/20. Advertisement dated 5/6/20.
Much obliged. It's at page 48.
5/6/20.
May it please your lordship. My lord, these petitioners had applied for the post of Anganwadi helper, my lord, as per the advertisement dated 18/7/2025, my lord. And the
Yes, Mora, what happened to that?
Lordship, I'll take instruction, my lord, 1 week time maybe.
Heard Miss Aras Theory, learned counsel for the petitioner. Also heard Miss B. Bora, learned standing counsel, BTC. Ms. Bora submits that she would receive instructions as to the status of the recruitment exercise initiated in pursuance, initiated for engagement as Anganwadi worker. Helper. In pursuance to the advertisement dated 18/7/2025. When will we have it? 27th?
27.
Register to list this matter again on 27/8/7.
my lord, till then, no re-advertisement may be.
If they do it, I am here, you come back.
Yes, obliged, my lord.
I'm obliged.
Next.
Same.
Next, my lord, same, my lord.
20, same.
Advertisement dated different, my lord, on
Advertise to date to
16/7, my lord.
16/7.
Obliged, my lord.
Lordship, may I pray, my lord? In this matter, senior counsel Mr. A.K. Bhuya will appear, my lord.
Item number 24.
24, my lord.
Who wants to appear?
Yes, my lord.
Okay.
Can be.
Well, what is your ground for challenge?
Ground lordship, now if your lordship comes to page 76, the impugned.
That ground is given, then it's a genuine ground.
Now page 34. Page 34. This is the order passed by this honorable court on
Forget
11/11/2022.
that order was not after recognizing these things. This court said, okay, if that is there, take it to its logical.
It was a submission of the Learned Standing Council BTC lordship upon instruction Miss MS R.B. Bora, Learned Counsel for the authorities in the BTC has made a statement that
Page.
page 34. WPC 3950 of 2021. Paragraph 3.
Meeting will be held 14/11.
There was an
Meeting held-
incident before this honorable court.
No, the meeting held. Where is the meeting results? Was the results directed to be declared?
Yes.
Where?
No, there is nothing. But meeting will be held.
Meeting held, and they have now come up with this detailed reasons.
The
And this-
advertisement of 2006.
Mr. Dhar, with this, can we direct them to take the selection process to its logical conclusion?
No, when the selection process was already completed, result was what to declare. But
Okay,
that
let Mr.
result
Bhuyan,
was.
let Mr. Bhuyan. Mr. Soikia, what are you waiting for?
Item 27, NC Hills matter. Let me wait, Lordship, for 2 matters.
Wait, lordship. In this case, at the time of entry, petitioner before lordship, his date of birth was entered.
You have retired.
My lord. I have retired.
Heard Mr. Ayat Soikia, learned counsel for the petitioner. Also heard Ms. Deepora, learned standing counsel, health and family. Welfare.
1 and 2, yes, lordship.
And also standing counsel, health and family welfare. Also heard Ms. S. Borua, learned government advocate. Ms.
On behalf of Talukdar.
R.K. Talukdar. He's there in court today. Mr. R.K. Talukdar, learned counsel, and Mr. R. Borpujari, learned standing counsel and Stefan. The petitioner in the present petition has raised a grievance with regard to the contemplated action on the part of the respondent authorities in proceeding to make recoveries from his pension and pensionary benefits on the ground that the petitioner had overstayed in his service for a period of 1 year.
1 year.
Full stop. The petitioner contends that in his service book, his date of birth was recorded as 2/12/1965, basing on a school leaving certificate produced by him in matter. From the materials brought on record, including a communication dated 13/4/2026, issued by the Office of the Accountant General (bracket ANE) bracket over Assam, this court does not find that any misrepresentation and suppression has been alleged against the petitioner in the matter of placing of documents before the respondent authorities for the purpose of determining his date of birth. Also, issue notice returnable 4 weeks. Ms. Bora accepts notice on behalf of respondent number 1 and 2, while Ms. S. Borua accepts notice on behalf of respondent number 3. Mr. R.K. Talukda accepts notice on behalf of respondent number 4, and Mr. R. Borpujari accepts notice on behalf of respondent number 5. Also, as all the respondents are represented, no formal notice. Also, till the next returnable date, it is provided that no recovery of the amount received by the petitioner as salaries for the overstay period shall be made from the pension and pensionary benefits of the.
One more prayer, my lord.
Also.
He has not been paid by the provisional.
It is further provided that before the next returnable date, the respondent authorities shall authorize to the petitioner a provisional pension in accordance with law, in accordance with law, full stop. The orders authorizing the petitioner his provisional pension shall be placed on record before this court on the next. Registry to list this matter again after 6 weeks.
Extra copies to be served, Lordship.
He will serve today. Serve him extra copies.
Lordship. Obliged, Lordship.
You got your thing. What more is required?
It's just a matter partners to non-payment of the minimum pay scale, madam. The Forest Department petition, madam. The petitioner are working since 2006 and 15, madam. Yes, madam, notice may be go, madam.
Notice may be issued, madam. Take instruction.
Heard Mr. A. Bora, Boro Learned Counsel for the petitioner. Also heard Ms. R.B. Bora, Learned.
Asha, I am Miss B. Bora, madam.
S.B. Bora. R.B. Bora.
B. Bora, madam.
B. Bora, sorry. Learned Standing Counsel.
I'm appearing for respondent number 4 to.
Standing Counsel, PTC. Who is for the forest? Also heard Mr.
I. Bora.
Thakur, bottom I. Thakur, Learned Standing Counsel, Forest Department, Ms. P. Bora, Learned Standing Counsel, PTC,
Asha, finance is also there.
and Mr. R. Borpujari, Learned Standing Counsel, Finance Department. The petitioners in the present writ petition has prayed for a direction upon the responsible authorities for granting to them the benefit of minimum scale of pay corresponding to the equivalent post in the regular cadre. Also, issue notice returnable 4 weeks. Mr. I. Borthakur accepts notice on behalf of respondent number 1 and 2, while Mr. R. Borpujari accepts notice on behalf of respondent number 3. Ms. B. Bora accepts notice on behalf of 4, 5,
6,
7,
8, and 9.
9. No formal notice, huh? Registry to list this matter again on 19/8/2026, right? Tendency of this present application must be a bar for the respondent authorities to consider the claim of the or being authorized their wages in the minimum scale of pay authorized to an equivalent post regular health.
Lordship, extra copies may be furnished.
He'll give it to you. If he doesn't give it, come and tell me.
I'm open.
It's of my letter.
May it please your lordship. Lordship, in this case, what has happened, lordship, an advertisement was issued by the NCL Autonomous Council, lordship. For the
This court you approached, this court directed
lordship,
to keep to, then you were appointed,
lordship,
then you were being shuttled around,
lordship,
and then they had said you are not required.
lordship,
Then they themselves withdrew that.
lordship,
Again, copy paste, same order.
lordship,
What is the reason? You don't know.
lordship.
Yes, Mr. Soikia.
Let me take instructions, lordship. A short date may be fixed.
But Mr. Soikia, this we will have to stay. This lady is being shuttled around like anything. You will appreciate.
I leave that to your lordship.
But Mr. That is the beauty of Mr. Soikia. He does not unnecessarily argue. Mr. Soikia, because see, there is an order.
I have gone through it, lordship.
Heard Mr. P. Bodolo, learned counsel for the petitioner. Also heard Mr. D. You will be appearing as the advocate.
Senior advocate, senior standing counsel, NC Hills.
Mr. D. Soikia, learned senior counsel and senior standing counsel, North Kachar Hills Autonomous Council. The petitioner in the present petition has assailed an order dated 4/7/2026 by which she has been released from the services of the North Kachar Hills Autonomous Council in pursuance to a decision as arrived at in the matter by the council, full stop. The materials brought on record reveal that the petitioner was appointed in pursuance to a regular selection of process and against a regular sanction vacant post. A perusal of the order dated 4/7/2026, however, does not reveal the reason as to why the petitioner's services were directed by the council to be terminated. Full stop. Miss P. Borua, learned counsel assisting Mr. D. Soikia, learned senior counsel appearing for the North Kachar Hills Autonomous Council, submits that she would complete her instructions by the next returnable date. When do you want it, Mr.
10 days later or maybe 2 weeks. In the first week of August.
August, okay. To facilitate Ms. P. Borua to complete her instructions in the matter and apprise this court about the reasons leading to the issuance of the order dated 4/7/2026. Registry is directed to list this matter again on 5th would be fine.
Lordship.
On 5/8/2026. Considering the fact that the petitioner was appointed in pursuance to a regular process of selection and against a regular sanction vacant post till the next returnable date, the order dated 4/7/2026 shall remain stayed. However, they said the present interim order would be reconsidered on the next date of listing on Ms. P. Borua completing her instruction.
Highly obliged.
Oblige, your lordship.
May I please, your lordship? What's the excess amount, withdrawal of excess amount, reading refixation, that is not the fault of the petitioner, lordship.
Mr. Borbuja, you have your instructions.
And
46 years only, he's got a long way to go. You have a long way, 1 lakh something, no?
Yes.
You make your recoveries then. For
Because-
time being, we are stopping it.
Yeah, because
This man apparently does not have any hand in this. It was an error, sure. We'll consider how to do it.
page 37 of the writ petition, Treasury Officer Dibrugarh has only disclosed the fact that it is liable to be recovered.
No, that's what.
Lordship, maybe please, for the timing, Lordship may take a call on this.
You continue to pay him in terms of the rectified scale of pay.
No, that is not the grievance. He is happy. But he is,
No.
yes.
Only thing, don't recover this amount.
Yes.
But Mr.
M. Ahmed.
M.
M. Ahmed.
M. Ahmed, learned counsel for the petitioner.
37.
Also heard Mr. R. Borpujari, learned standing counsel, finance department, and Mr. H. Chakraborty, learned standing counsel, learned government advocate. Anybody for AG? No. And Mr. S.K. Major S.K. Medi likibidi. S.K. Medi, standing counsel, accountant general. So the petitioner in the present petition is agreed by an order dated 16/6/2026, by which, while refixing his pay on his promotion, refixing his refixing the initial pay drawn by the petitioner as a junior assistant in Dibrugarh Treasury, a direction has been issued for refund of an excess drawal amount of rupees 1,86,825. Also, the petitioner contends that he is in no manner responsible for the fixation or for the initial fixation of pay, which is now being refixed by the order dated 16/6/2020. Also, issue notice returnable 4 weeks. Mr. Porpujari accepts notice on behalf of respondent number 1,
2, and 5, my lord.
and 5.
My lord.
While Mr. S.K. Medi accepts notice on behalf of S.K. Medi, accepts notice on behalf of respondent number 3, and Mr. H. Chakraborty accepts notice on behalf of respondent. So, considering the issue raised in the present, is provided that till the next returnable date, the order dated 16/6/2026, to the extent that it relates to effecting of recovery from the salaries of the petitioner, shall remain suspended. To that extent.
I oblige.
I'm so obliged.
Yes, Ms. Borua, what is it?
May I please receive one thing? Document verification was done by CISF, and CISF is not made party here, Lordship.
Okay, but the cancellation is by?
Lordship, at page 52, 50.
Cancellation is
Debarment order.
yes, Lordship, and debarred him to violation of the clause.
For staff selection commission?
Yes, Lordship.
Okay, so madam. But Ms. B. Chaudhary, learned senior counsel.
CISF has to be made in party, made party, Lordship.
No need. Because have you received instructions from staff selection?
CRPF. I have received instructions CRPF that they had not conducted the document verification. Document verification was
For the
conducted.
cancellation, why the document verification then? You get your instruction, you can ask them.
Yes, Lordship, but for cancellation and debarred
That is
station, that
the
is instruction SSC is
Only
party here.
enough. So this is inconsequential.
Yes, Lordship.
But Ms. Chaudhary, or you want them to have an instruction from the CISF also? You get an instruction from the CISF.
Yes, Lordship.
Huh? Ms. Borua submits that she be granted time till 27/7/2026.
Kindly, can it be on 30, Lordship?
30/7/2026 to complete her instructions from the CISF authorities as to why, after cancellation of the candidature of the petitioner, residential status verification, his residential status verification was being carried out. Registry to list this matter again on 30/7/2026. If there is something, we will give her that appointment. Otherwise, we'll cancel it. That's
yes.
Yes. One order was uploaded yesterday. The other could not be. It will be now done in afternoon. Yes. Yes.
Yeah, my lord, I have challenge on the ground, my lord. His transfer was issued manually. Whereas there is a provision, your lordship kindly see page 20, my lord. Page 20.
Page?
Page 20, clause 3. Transfer of the enrolled members of the force except inspectors shall be caused and carried out through TMM. There shall be no manual transfer for enrolled member of the force other than inspector except with the prior approval of the DGP RPF, my lord. Here what happened, my lord, all the transfers, my lord, has been issued through TMM. But in my case, my lord, it is manually without giving any
Yes,
choices.
In this, I'll take instruction.
you have been released
Yes, my lord.
in 26/6 itself.
26.
Where are you now?
I'm nowhere, my lord.
Mr. I. Rafiq, Learned Counsel for Mr. B. Kaushik, Learned Standing Counsel, CGC, appearing for the respondents. Mr. Rafiq has submitted that in terms of the guidelines issued under the provisions of Rule 28 of the Assam Protection Force Rules, Railway Protection Force Rules, 1987, more particularly clause
3 million.
Clause D2, the transfers of the members of the force is to be so done in done in an ICT application called ' Transfer Management Model, bracketed TMM, ' all. It is submitted that the transfers of the petitioner was carried out in a manual mode in violation of the provisions of clause D bracketed 2 of the said guidelines. So, Mr. P. Kaushik submits that he be granted a week's time.
Monday. Let it be Monday.
Tuesday. To complete his instructions in the matter. I accepted. List this matter again on 21/7/2026. It is seen that the petitioner, in pursuance to the order of transfer dated 25/6/2026, was already released from his services from the present place of posting from New Coach Bihar, Alipur Duar Division on 26/6/2026. Also, register to list this matter again on 21/7/2026. Yes. So these two would be the same.
Same.
In 64, the transfer is from where to where?
Jalpaiguri to Malak, Tinsukia.
Jalpaiguri, 64, Jalpaiguri pra, Tinsukia, 65.
Alipurduar to Katihar.
Alipurduar to Katihar.
In 64, I am appearing.
65, 64, you are appearing.
Yes, 65.
64 KK Parasa, 65 on B Kaushik. Ke bostu tumhari?
Obliged.
What is the clarification?
Lordship, only thing, your lordship may kindly still look at the additional affidavit. Here, your lordship, we have annexed it. There is nothing, your lordship. They have.
No. I know there is nothing, but there is a show cause notice.
Lordship, but your lordship will kindly see, along with the show cause notice, there is no statement of allegation, no list of documents, list of witnesses that is in the first show cause itself.
What is the stage of this proceedings?
Lordship, it is going on. 4 to 5 witnesses have been examined. And in lordship.
Heard Mr. S. Bhattakur, Learned Counsel for the petitioner. Also heard Mr. J.K. Goswami, Learned Additional Senior Government Advocate, appearing for the respondents. The petitioner in the present petition has assailed the departmental proceedings instituted against him while a show cause notice dated 24/6/2025 and 27, what is that?
27/6.
27/6. Page.
Your lordship, page
Page
118, your lordship.
And (27/6/2025). Also, the Learned Counsel for the petitioner has submitted that the departmental proceeding instituted against the petitioner is presently progressing and around 4 to 5 witnesses have already been examined and the petitioner is also participating in this inquiry. Also, considering the grievances, considering the issues raised in the present petition, first of all, the petitioner has submitted that the departmental proceedings instituted against him would not be maintainable inasmuch as in the corresponding criminal case, the petitioner, corresponding criminal case, the police on completion of investigation has submitted its charge sheet and the petitioner has not been implicated therein as an accused. Also, it is further projected by the petitioner that the allegations level in the matter against the petitioner would only reveal a negligence on his part would at best reveal a negligence on his part without there being any further allegation of misappropriation of the materials involved. So accordingly, the petitioner submits, accordingly, senior counsel for the petitioner submits that the proceedings, further proceedings in the departmental, further proceedings instituted against the petitioner in pursuance to the show cause notices dated 27/6/2025 and 27/6/2025 should be kept in abeyance. Also, issue notice returnable 4 weeks. Mr. J.K. Goswami, learned additional senior government advocate, accepts notice on behalf of all the respondent. Also, no formal notice. Considering the fact that the inquiry proceedings have progressed substantially, this court at this stage would not restrain the respondent authorities from concluding the inquiry involved. However, it is provided that till the next returnable date, the inquiry report, if submitted by the inquiry officer, the same shall not be further acted upon by the disciplinary authority without further, without leave, shall not be further acted upon also by the disciplinary authority. Because that will balance the.
That will balance. I'm sorry, my lord.
Oh, you need not be sorry.
My lord, the matter relates to, my lord, selection and appointment of Gram Pradhan, my lord, in a particular lot in Golaghat district, my lord. An advertisement had been floated and I did participate and accordingly got selection also, my lord. Now, the reason undisclosed, my lord, till date, my lord, I have not been even informed that what is the reason for not my appointment. My lord, keeping the earlier selection.
When is the last date?
My lord, the last date for the fresh advertisement, my lord, is the on at page, my lord, 55, 20.
Will be received till
My lord, that has not been yet.
6/7.
6/7, my lord.
So you have missed the bus. Have you applied in pursuance to this?
No, my lord, I am challenging this, my lord. I am challenging this.
Challenging this after the last date of application.
No, my lord, after the last date of application as because.
There was a select list published.
Select
in
list published,
22.
my lord.
What is the validity of a select list?
No, my lord, the validity of the select list under the rules, they have not provided any particular
Then the
date.
general validity would come.
No, general validity would come, my lord, subject to cancellation with the reason order of the earlier, just keeping.
You are concerned in page 55 with which lot?
My lord, lot number 1, Bokakhat Revenue Circle, this is, my lord, Tipujan Bagisia area, my lord. My lord, may kindly appreciate, my lord, there should be a reason for cancellation, my lord, as I have been, my lord, participated, selected, waiting for my appointment since long. Representation has also. That is correct, my lord. That is correct, my lord. But this type of in cases, my lord, there is an expectation that they may come up with the.
I got it. There would be an expectation, but whether that expectation is a legal expectation.
Legal expectation because, my lord, I have been legally selected by of a transparent and fair selection.
Where is this is by the revenue?
Yes, my lord. In the revenue department, my lord.
Yes,
Lordship,
Mr. Chakraborty. Without
Lordship, last date
cancelling
has
the
gone,
earlier-
Lordship, on 6th July 2006 to
Fine, that-
26,
that-
Lordship.
that-
That has
that-
been gone, Lordship.
That gone. He is selling the whole thing. The whole thing goes, what is that? Nothing.
Earlier was selected,
Get
Lordship.
your instructions.
On 30th, Lordship, on
On
30th of July, Lordship.
27. 27.
Lordship.
Till then, they may not finalize it, my lord.
That's it. But Mr. A.R. Bhaiya, Learned Senior Counsel, assisted by Mr. Huh?
M.A.I. Hussain.
M.A.I. Hussain. Getting old maybe, that's why not retention power is gone now. M.A.I. Hussain, Learned Counsel appearing for the petition. Also heard Mr. A. Chakraborty, Learned Government Advocate. Also, the petitioner in the present writ petition has projected that in pursuance to advertisement dated March
25/8/2021.
25/8/20, he had submitted his candidature application for being considered for recruitment as a Gaon Pradhan, as a Gaon Bura against the post of, which post did you?
Hello,
apply?
that's serial number 20, page 15, Milo. Serial number 20.
Post of Gaon Pradhan for the villages, page 15, A to A, huh? So, the petitioner contends that thereafter he had participated in the selection process and on being found and was selected for being appointed as the Gaumbura against the said villages wide a select list published on 29/12/2022. It is projected that the said that appointments were effected from the said select list. However, no such appointment was effected in respect of the petitioner, and he was pursuing the matters with the respondent authorities over the period of time. It is further projected that without issuing any order cancelling the earlier process of selection initiated by the advertisement dated 25/8/2021, the respondent authorities have again advertised the post of, now it is Gaon Pradhan.
Gaon Pradhan, my lord.
Of A to A. B to B, huh? Page 55. Now the area has gone up.
My lord. Some differences is there, my lord.
A B to B.
Serial number
Also,
1, my lord.
accordingly, the petitioner has essayed the fresh advertisement dated. Fresh advertisement dated
My lord, this is dated, my lord, 6th of
21. 25th. 25th, 8/21. 8/21.
No. The subsequent.
press advertisement.
Advertisement dated
Page
3/6/2026. 3/6/2026. 3/6/2026. Also,
36.
issue notice returnable 4 weeks. Mr. J. Handik. Mr. Handik, you are appearing for whom?
For 1 and 2 lots.
Mr. J. Handik, Learned Standing Council, Revenue and Disaster Management. Mr. J. Handik accepts notice on behalf of respondent number 1 and 2, while Mr. A. Chakraborty accepts notice on behalf of respondent number 3 to 6. Considering the contentions raised by the petitioner in the present writ petition, this court provides that till the next returnable date, the selection in that no appointment be effected in pursuance to the selection to be held, no appointment be effected against the post of Gaon Pradhan for villages B to B. However, the respondents are at liberty to conduct the selection and publish the to conduct this, to complete the selection process. To complete the selection process.
Obliged, deeply obliged.
Mr. Sinha.
Yes, my lord.
Where is the inquiry report?
We have not been given the inquiry report. Because even we do not know even the inquiry was
So you have been given page 38.
so much.
Yes, come to page 38.
No matter this is a 38 of my application, writ petition.
Writ petition.
No matter this is a representation I have submitted.
Representation against the inquiry report.
Yes, madam.
I just want to know whether the inquiry officer had issued notices to you. That's all.
No, because he has issued notice.
Then,
But no, whether the notice is served to me, my lord, because I am at village. And
then, how did you get the inquiry report?
inquiry report I did not get, madam. I have given the
Then
judge.
how have you annexed your memorandum of charge? If you have not received your memorandum of charge, how have you annexed that a copy here? Where is your explanation from where you got it?
Yes, madam.
Okay, who is appearing for the respondents?
Respondent has filed affidavit, my lord. My writ petition is lacking documents, my lord, but rather respondent affidavit is having all the documents.
Where? I don't find any document.
In affidavit.
Affidavit.
Yes, my lord.
Okay.
Respondent's affidavit is having all the documents.
Come to the inquiry report then.
There also, my lord, your lordship will find.
Nothing is here. Okay, sorry, that letter is against the. And that is you, it was forwarded to you on 24/1/2007. Then you replied the inquiry report.
And others, my lord, the others which have, my lord, whether communication made by the authorities were served upon me, my lord. No, my lord, no such, my lord, records are also there, my lord.
Okay.
They have simply issued notice.
Sinha,
Yes.
did you receive the order of penalty?
Later on, my lord.
When?
Later on.
Where? Show me.
Later on.
Just show me that.
Order of penalty, your lordship will find.
Page 39.
Yes, 39. No.
When did you receive this?
Page 39. G.
If you had received this in 2007, why should we entertain a writ application of 2017 after 10 years?
My lord, your lordship will find against the SOCOS reply, second SOCOS reply, the inquiry report, whatever your lordship says, my lord, as per record, I have not received the inquiry report, my lord.
So tell me, how have you annexed these documents then? From where did you get these documents?
It was served on me. Naturally, it should be served on me.
So it was served upon on you
But
on in two
on
thousand.
that condition, whether notice, why I have remained.
Sir, we'll
Yes,
come to
yes,
that.
yes,
We'll come to that. How have you annexed 24/1/2007? If you have not received it, because you have submitted a representation against the inquiry report.
Yes, my lord.
Page 36. Then page 39 order, you have also brought on record. Now show me from the pleadings that these documents were never served on
Served
you.
upon me, man. Yes, I'll check.
Because these documents have been served upon you prior to 2010.
There is also one cause, my lord. Why not at that time, relevant time? Why it is up to 2010?
Very casually done.
My lord, a person who is one side is paralyzed.
I got it.
Yes.
We'll come to that. That is the reason. But now you demonstrate that you were not in a position to respond that because you would have not received the documents.
Give me just 5 minutes time, my lord. I'll just search it out, my lord. The next item, my lord, you are my lord.
No, why next item? 2 o'clock we'll have.
Okay, then type 2 o'clock.
Just show me that.
Yes,
that
yes, yes.
We have something to.
Yes, yes, yes.
Hey, please, your lordship. Lordship, as per an advertisement dated, my lord, 18/6/2015, my lord, this petitioner participated in a selection process, my lord, for the post of attendant, my lord. Thereafter, on 27/11/2015, my lord, written test was held, my lord. Written test was held, and thereafter, my lord, on 21/5/16, result of the written test was declared. Thereafter, my lord, the petitioner along with other candidates, my lord, appeared in the viva voice, my lord. Thereafter, what has happened, my lord, the results were not declared. So one of the aggrieved parties filed one writ petition before this honorable court.
Forget that. That is of no consequence as far
Yes.
as you are concerned. Because after that, they have taken the process forward. You were given the chance to appear in the written examinations, viva voce and all those.
Everything was completed, my lord.
Completed. But the results were not declared.
Results were not declared.
Then
Results
they
were
issued
declared.
this order at communication at page 33.
Page 33 is the impugned order, my lord, whereby the entire selection process has been cancelled, my lord.
And the reasoning is that it was so done unilaterally by the principal and superintendent, chief superintendent, Tezpur Medical College without approval of the government. What do you have to say?
But after participating in every selection process, my
You
lord,
participated, good. But if the very initiation of that selection is in violation of the norms, why should that be required to be taken forward? It's not only in you, all this election has been set aside.
results of the some candidates are declared, my lord.
Whether appointed.
Appointed or not, I don't have that.
After you should have known that in 2017 itself when you
Yes,
filed
my
this
lord.
case.
And it's a GNH, my lord.
I've
This is
seen
the
it.
results.
But here they say, Thursday selection stands cancelled. Grade 3 and grade. All the selections appointments were cancelled.
It appears so from this order.
Tell me.
Yes.
Tell me. If you have done it selectively.
Yes.
If you have done it selectively, then his case, he has some case.
Lordship.
Because here,
GNH lordship will see, my lord, there's no signature and all, my lord. It's
credit.
Yes.
Here,
No date.
you will find that from the grounds, the very advertisement is bad. The advertisement had number of posts.
Yes.
So
It's simple
if
advertisement.
you have selectively permitted some to continue, others to go, that will not.
My lord.
Can you just have a telephonic instruction?
That I can have.
We'll take it up after some time whenever you have that.
Yes, sir.
I mobilize you.
If you have cancelled
And
all the selection to all the posts advertised, we'll dismiss this. But if you have selectively permitted, then we will.
lots of.
I mobilize you, Lord.
May please the Lordship, the matter relates to regularization of service of the petitioner, Lordship. Matter relates to regularization of service of the petitioner, Lordship. After the death of her brother, Lordship, the post fall vacant and she was appointed temporarily on that basis. And she is getting.
You are still working.
Yes, Lordship.
Yes, madam. Regularization will not be there. But a minimum scale of pay, why is not being paid?
Lordship, as per my instruction, she was on the daily wage, regular wage in the year of 2016 only, Lordship.
Who?
The petition.
She will not be regularized.
Regularized.
But he is doing some work. Why this meager amount is being paid? Why not on some amount, dignified manner she can live? Without she coming to the office, nobody can come. It is only because of you, her services, that the others are working peacefully in the office. If the cleaning activities are not carried out by the staff, can we come into this courtroom? Yeah, important people.
Yes, Lordship. So for my instruction is that
I'm not with her regularization. That
Yes,
you
it's,
say stands rejected. But what about she is working from 2016, last 10 years she is working. And she is getting only a meager. How much are you getting?
1,000.
1,000 per month.
Uh-huh.
Lordship, if she is working till that instruction is not with me, Lordship. If she is working.
You have not said in your affidavit also that she is not working.
If she is working.
That is below.
Lordship.
That we will pass appropriate orders. From that day, we will ask you to.
If she is working till date, then I will ask for some instruction in consider this matter, Lordship.
Miss M. Kotoki, Learned Counsel for the Learned Standing Council, Animal Husbandry and Veterinary, Animal Husbandry, Veterinary and Animal Husbandry, or Animal Husbandry and Veterinary?
Animal husbandry and
Animal
veterinary.
Husbandry and Veterinary submits that she be granted time till 4/8/2026 to complete her instructions, to receive instructions as to the petitioner is continuing in her service and as to whether the wages received by the petitioner has been enhanced. It is projected by the Learned Counsel for the petitioners that the petitioner is continuing in her services at a monthly honorarium of only of a meager monthly honorarium of ₹1,000. Ms. Kotoki shall also receive instructions as to why the honorarium received by the petitioner is not to be increased at least till to the minimum of the pay scale received by a grade 4 employee in the establishment wherein she is.
Obliged.
Register to list this matter again on 4/8.
Right, Lordship.
We have filed our affidavit in this matter, Lordship. Lordship, this matter pertains to cooperative department, Lordship. Cooperative societies.
Department?
Lordship, this is not for any dairy
No,
department.
it is under you only. Your director appointed him.
Director, but Lordship, the cooperative society, under the Cooperative Societies Act, this matter belongs to, so they have to implement the cooperative
This
society.
is no cooperative society. This is your thing.
Kindly see page number 19 annexure to Lordship. Page 19 annexure to.
Deputy Director,
Deputy
Dairy
Director.
Development.
Engagement.
Now do one thing. This man is maybe not there. Buragoy, H. Buragoy,
Yes,
Deputy Director
yes,
is not there.
not there.
You have paid him apart, 37,500.
Yes,
Why
Lordship.
not the balance amount? Admittedly, he worked. Nobody has challenged his appointment. You say that there was a selection, the respondents had directed 1 and 2 to be appointed. But he was at some serial number 30 or something. He was appointed. But nobody challenged that. This is just a temporary appointment. He worked. Pay him.
Lordship, one apex court judgment is there.
Yes.
1,42,500 is the balance, Lordship.
This thing we will not see. There is a inquiry report also.
Yes, Lordship.
Then will we dispose it of with that direction? Or you want to have some instruction?
I have to want some instruction, Lordship. 1 week time, Lordship.
On the prayer of Miss M. Kotoki, petitioner. Standing Council, Animal Husband, Veterinary. Basically to list this matter again on 28/7/2026.
Lordship, on,
further hearing.
is it possible on 4th, Lordship, 4th of
So
August?
date may be given, Lordship.
This is simple.
No, Lordship, I have some personal difficulty on
Will not be
20th.
here.
I'm not be here
When?
till 31st, some difficulties there, Lordship.
From when are you not here?
Lordship, may fix this matter on 4th also.
24.
24th, Lordship.
23. 23.
20, oh, Lordship.
23. Sir. Further hearing. What heard the Learner Council for the. Yeah.
Obliged, Lordship.
You give it to me on the next day.
My praise your Lordship, my lord.
Yes, Mr.
My lord, although I have.
After a long time, Mr.
My
Purkhal.
lord. My lord, in this case, perhaps my lordship cannot take up the matter. Because in connection with this subject, my lord, there was a writ petition and my lord appeared as a.
Where?
Yes, my lord.
Where is that petition that I have here?
Judgment.
Where?
My lord, at page 86.
Oh, this is totally different. This has
No,
got
wait, my lord, in terms of interim order pass, our promotion was, my lord, stopped. Our promotion was
okay.
with
On
him.
the prayer of Mr. A.K. Purkhal, the Learner Council for the petition. Full stop. Register to register to list this matter before any other bench with.
My lord.
Yes, what is the qualification?
Yes, Lordship, I have received one instruction, Lordship, but that instruction is not sufficient as per last order, Lordship. So I may be at least.
22/6 we had directed.
Lordship.
I want that complied
No,
instruction.
Lordship has directed us to place at least 10 instances where both degree and diploma has been provincialized. But in this case, Lordship, one instruction.
Why this is not served to you?
Lordship, the one instruction I have received that it is respectfully submitted that under the provision of Rule Act 2017, the service of library assistant were provincialized on the basis of possession of graduate degree alone. So
He has a graduate degree.
yes. So let the matter be fixed day after tomorrow, Monday, Lordship. So I'll have to clarify whether this is in compliance with that Lordship earlier direction or not.
Let it be not in compliance with that. But
Lordship.
if you say that only a degree qualification is enough, he has it. You have it.
Yes, he has a. At two, I'll have to some the clarification on this instruction, Lordship. Whether this is in pursuance of Lordship earlier direction or not, Lordship.
Mr. P.P. Dr. Learned, Standing Council, Department of School Education has submitted that he has received instructions in response to the queries raised by court-wide order dated 22/6/2026. However, he said
22/6.
that he would require further clarification of the matter and accordingly prays that the matter be taken up on 28/7/2026.
Lordship.
So no further adjournment shall be granted in the
Lordship.
Please free to list this matter again on 28/7/20
Lordship.
for further hearing. If that be so,
Yes, Lordship.
please too will
He is entitled. That.
Mr. Khan, wait for.
Yes.
Time has not come.
Lordship.
Yes, what do you say on this? Who is there?
My pleasure, Lordship.
Hmm.
So actually, ma'am informed is another court, so I see. Respondent, I don't know for the name actually, respondent authority. He's taken some time, actually busy in another court.
Ms. Sharma is here.
Yes, sir.
Ms. Sharma,
Lordship.
there is a report of the Gauhati Medical College Hospital now, wherein they say that it is okay.
Yes.
Hearing and everything is okay. To examine on basis of this.
On the last occasion, in fact, Lordship, while going through it, Lordship had observed that at that time, there was some.
Something, but now.
Yes, Lordship.
Now that they have, it has now this court
And
having required him
Lordship
to
asked
have.
me that want to take a copy of the order that review medical board decision is final on the last occasion. And there are many judgments of different high courts, although I have not brought that civilian doctors, standard of civilian doctor and standard of medical practitioner of force, Lordship, there is a difference.
But the issue here is that perforation is not there now. It may have become okay in the meantime.
But there is nothing.
Okay, tell us.
Nothing illegality
That
because
day, if on that day it was there and subsequently it has been redressed or it has subsided, what is the error in the decision of the?
and specialist opinion was there.
I had to go on immediately thereafter to the GMCA is that it is, so perforation is totally completed. Okay. You can see the annexer, Lordship.
Unless there is any malafide on the part of the respondents. So generally,
Page 54, Lordship.
scope is less to interfere because we have examined him with MS or this specialist, Lordship.
As so the report of the Gauhati Medical College Hospital has already been placed on record. You have received copies of this report?
No.
So the courtmaster is required to punish. It's a copy. To punish to the learned counsel for the respondents. A copy of the communication dated 3/6/2026 and the report enclosed thereof of the medical board constituted in the Gauhati Medical College and Hospital for examining the petition and hearing. So the parties to make their respective submissions basing on the said report on the next date of listing. Registered to list this matter again on 5/8/2026. The matter be not treated as parted and or tied up matter with this court any further. Another copy.
Lordship, in this case, so cause was issued that why penalty shall not be inflicted on 1 to 3,
Now
but penalty was completed under so and so.
Cannot. They're interfering.
We are praying that to maybe granted liberty to a de novo, Lordship. And he shall not be, Lordship, reinstated till then, Lordship.
Second of 45. We'll dispose it of today.
Lordship, we have filed an affidavit in opposition today, Your Lordship.
Mr. K, you have received a copy?
I have received, these cases are covered by Sukhendra Bachcharji, my lord. Item 32, 34 and 35.
But 30,
32, 34 and 35. Yeah.
32, 34,
Should we take
35.
on
34,
29,
35, I guess, 32.
I am
Mr.
appearing in
K,
32.
You have filed an affidavit in WPC 1739.
Yes, Your Lordship.
Submits that an affidavit has been filed by the respondents, 1739, today. Registry to list this matter again on
29, my lord.
30, 30,
My lord,
7,
on 29, my lord, I will also make some argument, my lord.
Huh?
I will also make some submission, my lord, on 29.
29, okay, 29, 7, 2020. 34, 35 would be as agreed to by the learned council for the parties, registry to list this matter again on 34, on 29, 7, 20.
Obliged, Your Lordship.
Obliged,
Miss R. Datta is present for the respondent number 5. 32 and both 32, 34, 35. All respond number 5.
32 and 34.
32 and 34.
Obliged, Your Lordship.
None appears for the petitioner on call. For the ends of justice, registry this matter again after 3 weeks on a date to be fixed. Yes, Mr. Goswami.
Mediation report is there, my lord.
Unsuccessful. Oh, the report was there. Settlement agreement, okay.
So in terms of that, it may be closed.
Mr. Goswami, you have signed on whose behalf?
My lord, the writ petitioner.
Also agreeable to this.
Lordship, that is agreeable. Only
What we
thing,
do
your
is that, what should we do now? We'll have to just copy paste the settlement agreement and direct you to act on.
Only development that had taken place in the meanwhile, the mother died. That will go, your lordship, her share will go as per your lordship succession law, your lordship.
Should we indicate or it will be not? He was a party respondent.
Yes, your lordship.
It's better indicate the.
Your lordship may indicate it. Other three will get the equal share.
Equal share. Mother is respondent number 4.
Lords,
You are representing.
lords.
Deepika and Munmi are the daughters of the first wife.
Lords.
Deepshika, 3 daughters.
Deep Sakha, your lords.
Daughter, but one has already been died, but prior
Died.
to that,
Died.
Died.
2 daughters are there.
2 daughters.
They were made
Deepika and
parties to the
Deepshika.
proceeding.
What is settlement? Settlement.
But Mr. UK Goswami learned also heard Ms. S. Borua, government advocate, appearing for the owner number 1, 2, 3. Also heard Mr. S. Bothakur, learned, assisted by Mr. T. Soikia, learned, still appearing for the respondent number 5 and 6. Mr. Bothakur at the outset has submitted that during the pendency of the present and after the settlement was arrived at between the mediation, before the mediator, comma, the respondent number 4 had passed on, comma, on.
Your lordship. I will inquire and
On so and so. The present writ petition has been instituted by the second wife of Subal Bora, who was working as a Nayak, the Assam Special Reserve Force. Subal Bora, on account of ailments suffered by him, had passed on, comma, on 2/7/2018. Thereafter, a dispute had arisen with regard to the manner in which the pension and pensionary benefits receivable by the next of kin of late Subal Bora is required to be apportioned. So, the respondent number 4 is the mother of late Subal Bora, while respondent number 5 and 6 are his daughters, are the daughters born to him from his earlier marriage with Bharati Bora, who had predeceased him. So, the present writ petition on being filed and with the consent of the parties, comma, this court-wide order dated 23/2/2026 had referred the parties to mediation. So the parties accordingly appeared before the mediator, and in conclusion of the process of mediation, a settlement agreement was signed between the parties, more particularly petitioner and the respondent number 4 and 5. The respondent number 4, who was alive at the relevant point of time, had also expressed her consent to the terms of settlement. So, the terms of settlement being relevant is extracted. Extracted here in bill. A2. Also, the above settlement being arrived at by and between the parties and the parties having supported the said agreement, settlement terms before this court, comma, the respondent authorities in the Home Department are directed to release the pension and pensionary benefits in pursuance with respect to the services rendered by late Subol Bora strictly in the manner as agreed to, strictly in terms of the settlement arrived at between the petitioner and the respondent number 5 and 6. With regard to the share required to be apportioned to respondent number 4 in terms of the said agreement, comma, respondent number 4 having passed on, comma, on, dubar date of this court in terms of the agreement arrived at between the petitioner and the respondent number 5 and 6 directs that the amount receivable by the respondent number 4 be shared equally between the petitioner and the respondent number 5 and 6. Anything more is required, Lords? The respondent authorities on receipt of a certified copy of this order along with the settlement agreement arrived at certified copy of this. You can take a certified copy of this. Certified copy of the settlement agreement arrived at between the petitioner and the respondent number 5 and 6 shall expeditiously process the matter and authorize to the petitioner herein the compassionate family pension and authorize to the petitioner and the respondent number 5 and 6 other pensionary benefits in terms of the settlement agreement within a period of 2 months, 3 months from the date of receipt of a certified copy of this order from either of the parties to. So, with the above observations and directions, the present stands disposed of.
Obliged.
Lordship, in this case, Lordship, PPO and GPO has been issued, Lordship.
Nothing more survives. You have got it. In terms of the also heard Mr. T.H. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. Ms. P. Chakraborty, Learned Standing Counsel, Water Resources Department, comma, semicolon, Ms. S. Burwa, Learned Counsel, the government advocate appearing, no, the government advocate here, government advocate for respondent number 3, and Mr. R.K. Talukdar, Learned Accountant, Learned Standing Counsel, Accountant General, bracket A&E, some representing the respondent, appearing for the respondent number. Mr. R.K. Talukdar, Learned Counsel for the Learned Counsel, Standing Counsel, Accountant General, Assam, has submitted that the pension proposal received in respect of the petitioner, family pension proposal received in respect of the petitioner, has been processed and finalized. He submits that the family
pension,
it's a PPO.
Pension, Lordship, family, not family.
Family pension, respect of the submits that the PPO bearing number 916711342136 dated 10/7/2026 has been issued to the petitioner along with a GPO bearing number 712342133626 ma underline koi thodi silo.
Address to the treasury officer, Highland.
Dated same 10/7.
Same, Lordship.
10/7/2026. It is submitted that a copies of the same have already been forwarded to the petitioner and the jurisdictional treasury officer for further requisite action in the matter. Also, in view of the said developments, Mr. P. H. Chaudhary submits that no further live issue arises for duration the present. Accordingly, the petition may be closed. Full stop. In view of the issuance of the pension payment order along with the gratuity payment order to the petitioner, this court holds that no further live issue arising for consideration by this court, the present stands closed. Copies of the pension payment order as well as the gratuity payment order placed on record by Mr. R.K. Talukdar is furnished by Mr. R.K. Talukdar is kept on record and marked as X and X1 respectively for the purpose of identification. Huh? You will give him a copy.
Lordship, I have already.
My lord, here in this case, we have filed our rejoinder, my lord, and also filed one additional affidavit, my lord, to bring the record of, my lord, newly issued, my lord, 2 advertisement, my lord. One is of this month, my lord, 8/7/2026. My lord, I'm just. My lord, these 2 advertisement.
You want to bring it on?
My lord, yes, we have already filed it, but my lord, this one is of, my lord, 8/7/2026, and other one is, my lord, 25/2. My lord, matter may be, my lord, taken up for final consideration, my lord, by as per your
When do you
lordship's
want?
conference. My lord, next week, any day, my lord.
Next week, the week next, tied up.
My lord, as per your lordship's convenience. My lord, till then,
As
my lord,
agreed to by the learned counsel for the parties, it is submitted that the pleadings in the matter is complete. As agreed to by the learned counsel for the parties, pleadings in the matter is complete and the matter can be taken up for final consideration. As agreed to by the learned counsel for the parties, the registry to list this matter again on 6/8/2026.
my lord, till then, my lord, these 2 advertisement may be, my lord.
No,
Without a
Lordship, this
challenge,
cannot be.
How can I do it?
There is no challenge and we have
You
not
have to
received this.
file a
Yes, Lord.
interlocutory application at
My lord,
least.
already filed, my lord.
But that you bring it,
No,
mention it,
this
bring it.
cannot
we'll
be.
see.
My lord, already filed through additional.
Yes, sir, I
affidavit, my
can't,
lord.
I can't do that. This was done in Calcutta. High Court once. Supreme Court deprecated that. That's a reported judgment. Earlier, you need not file a writ petition. You can just place the documents before the court. The court on perusal of that could have passed an order. That was the once a situation. That has been there.
Right, my lord.
Bring it in the proper manner, we'll do it.
Obliged, my lord.
Obliged, your Lordship.
Your Lordship, the GPF amount of the petitioners has already been released, Your Lordship. And the pension proposal is uploaded in Kitagata portal. And the provisional pension.
None appears for the petition on call. Mr. K. on instructions have submitted that the pension proposal in respect of the petitioner has already been uploaded to the
Kitagata portal.
KRITAGYATA portal, huh? Kitagata portal, and the same would now be processed further by the Director of Pensions, huh?
To the AG, Your Lordship.
Or by the Accountant General Assam. By the establishment of the Accountant General Assam.
Yes.
It is further submitted by Mr. Kaur that the amount under the General Provident Fund scheme has already been released to the petition, has already been sanctioned to the petitioner,
Yes, sir.
and
Provisional pension. Your Lordship.
the benefits received by the petition, receivable by the petitioner, against leave encashment and group insurance scheme is also at an advanced stage of processing, and the amounts involved therein would also be released. So in view of the said developments, Mr. Kumar submits that the matter be taken up.
Your Lordship, so far as provisional pension is also concerned, order has been issued, Your Lordship.
He further submits that a provisional pension has also been authorized to the petitioner.
Yes.
So in view of the said developments, Mr. Kumar submits that the matter be taken up on when? You give me a date, Mr. Kumar.
Lordship, the month of August, Your Lordship, any date, Your Lordship.
On 28/8/2028, on which date he shall receive update instructions and apprise this court about the developments, further developments taking place in the matter. Prayer accepted, registry to list this matter again on 28/8/2026. Copy of the instructions furnished by Mr. K. Kumar, learned K. Kumar, learned additional advocate general, appearing for the respondents, is kept on record and marked as X for the purpose of.
Obliged, Your Lordship.
My lord, kindly see the last order, my lord.
My lord, in 2 weeks, the amount will be released, my lord. I have been informed by the.
Mr. I. Borthakur, learned standing counsel, Forest Department submits that the amount claimed by the petitioner as medical reimbursement would be released to him within a period of 2 weeks from today. Accordingly, he prays that the matter be taken up on 7/8/2026, on which date he shall place on record the order sanctioning the said amount to the petition.
Oh, I will.
Yeah, please, Your Lordship. So I've been dismissed from the service and.
Lordship, it is already sent, Lordship, but I have not yet received the signed copy of the affidavit, Lord.
Oh, affidavit.
Affidavit.
Yes, what is the ground for your dismissal?
Lordship, my natural justice has been violated. I was never allowed for cross-examining the witnesses, Lordship.
Lordship, just 1 week time, we'll be placing on record.
Where is the order?
Your Lordship will find the order, dismissal order at the annexure F, Lordship. It's a 40.
Type copy.
Yes, Lordship.
Okay, show me your show cause.
For a so-called notice is Lordship, page number 18.
Who had deposed against you with regard to that conversations between you and the drug peddler?
My fellow colleagues, Your Lordship.
Have done it.
My fellow
And
colleagues.
was that call records also?
Yes,
exhibited?
yes.
Then what is left?
Lordship, even my appeal has been dismissed, so I submitted one application for cross-examining the witnesses that has been not allowed, Your Lordship.
Forget that. Forget. To admit that these materials.
Lordship, I rendered my service with utmost sincerity and honesty.
But with connection with the drug peddlers.
No, Lordship. That is absolutely false, Your Lordship.
Okay.
There is also few statements, Lordship, where it has been evident that I was considered as the most reliable input, Your Lordship, to nab the drug peddlers, Your Lordship. The allegation is that, Lordship, I have taken some illegal gratification from the drug peddlers, Your Lordship.
Heard Mr. A. Chaudhary, learned counsel for the petitioner.
Yes, Lordship.
ISN,
Yes.
learned counsel for the petitioner. You're not there in the case.
No, my name isn't reflected, Lordship.
Also heard Mr. Miss M. Bachaji, learned counsel for the additional senior government advocate appearing for the respondents. Ms. Bachaji submits that that an affidavit on behalf of the respondents represented by her would be filed without fail on or before 28/7/2020.
Lordship.
So, registry to list this matter again on 31/7/2026. Ms.
Lordship.
Bachaji invariably shall also place on record the original file or the records of the departmental
Proceedings, Lordship.
instituted against the petitioner in original on the next date of listing without fail. So, registry to list this matter.
31st, Lordship.
Just want to know how the materials were
Lordship.
used against him
The original.
and his plea that he was not given. an
Not
opportunity.
given. Lordship.
Charges may be serious, but that will not permit you to
Yes, Lordship.
do away with.
Denying cross-examination.
If that is there, we'll remand the matter.
Lordship.
That ex-
Absolutely.
So let's
Lordship.
wait and see.
Deeply obliged, Lordship.
Yes.
Lordship, here is the rejection is a good dental point. Hypertension.
You're not filing a response. Rejoinder. You want to file a rejoinder? No. It is submitted that the pleadings in the matter is complete, that an affidavit in the matter has been filed by the respondents and the petitioner not filed any rejoinder thereto. Accordingly, registry to list this pleadings being completed in the matter, registry is directed to list this matter again on 11/8/2026 for admission hearing. An endeavor would be made to dispose of the matter on the next day.
Pension, my lord. My lord, India 2013, my lord, they have resubmitted the pension proposal, my lord. Until that, my lord.
Yes, Mr. Where is Mr. Talukdar? Yes, Mr. Talukdar, what has happened?
No, my lord,
Lordship, we are yet to receive
my lord,
Lordship pension proposal, Lordship, I think, because
there are some, we have just sent it, my lord. We have recently sent it, my lord, the proposal, my lord.
When?
My lord, I have just placed the instruction, my lord, before your lordship.
You have already submitted it to the AG's office.
Yes.
Mr. Ad hoc, Learned Standing Council, PWD submits that that a pension proposal in respect of the petitioner herein, along with all requisite documents, has already been forwarded to the establishment of the Accountant General, A&E, bracketed A&E, Assam, for further processing and disbursement and authorization of pension and pensioning benefits to the petitioner. Mr. R.K. Talukdar. Learned Standing Counsel, Accountant General shall receive instructions as to whether the said proposal has been received,
Today's letter, Lordship.
not received.
No, Lordship, this is the instruction of today, Lordship. They have forwarded today, Lordship. At 11 AM.
Maybe, my lord. Oh,
Shall,
File.
shall submits that the proposal on being received in the, by the
online.
establishment of the Accountant General A&E, the same would be expeditiously processed and the pension and pensioning benefits authorized to the petitioner. He submits that he be granted further 8 weeks' time. 8 weeks? More.
Lordship. Only 2 weeks, Lordship, because today they have signed, Lordship.
No. How much time do you want?
Only 2 weeks, Lordship.
You'll process it.
If pension paper proposal.
For further 2 weeks' time to further 3 weeks' time to complete the processing of the matter and issuance of pension PPOs in the PPO pension payment orders to the petitioner. Subject, however, to the condition that the pension proposal submitted by the departmental authorities is complete in all respects. Registry to list this matter again after 3 weeks. Registry to list this matter again on 14/8/2026, on which date Mr. Talukdar shall apprise this, shall receive updated instruction and apprise this court of the further developments taking place in the matter.
Smell.
Okay.
May I please, Your Lordship? Lordship, in this case, Lordship, the petitioners on a selected candidate FEBN, Lordship. And there are one criminal case before this honorable trial court, Lordship, and for which they did not participate in the training, Lordship. And now the petitioner is get acquittal, Lordship, from this trial court. The petitioner now get acquittal, Lordship, from the trial court, Lordship.
Basically, Lordship, it is wrong information, false information. Information regarding the pendency of any criminal case, he stated no pendency. After verification, it appears that there is a pendency of there was a pendency of the criminal case. Subsequently,
What is the nature of that criminal process?
that is 498A, Lordship. That was disposed of. Now he was acquitted, Lordship.
And the system
By the judgment of by the judgment and order, it is
But
that
in the form he had given that he
yes.
was, why did you give that?
Lordship, test 63. In my reply, Lordship, test 63.
No. Where is your form? Was any order issued? Any order issued terminating or
No, not.
rejecting?
No, Lordship.
Pleadings are complete.
Yes.
Yes, Lordship.
It is submitted that the pleadings in the matter is complete. Registry to list this matter again on when? When do
Lordship,
you want it?
2 weeks, Lordship.
Lordship, may it fix.
First, second week, third week, when?
First week
First week. On 4/8/2026
of Lordship.
I got the form.
for admission here.
This case, my lord, the respondent filed affidavit, opposition, I also filed reply, my lord. The major content is that, my lord, EWS certificate, my lord. And EWS certificate will be submitted. Kindly see, my lord, page number 134, my lord.
Pleadings complete.
Complete, my lord.
You'll hear it.
My lord.
Same order, huh?
48.
No. 7-8.
My lord. Oblige.
Lordship,
You're
they
not
have-
missing.
My lord,
You're not missing.
not motion.
You're here.
They, as a hectic demand, they have filed an affidavit of opposition. I'd like to file a reply, my lords. I'm challenging.
That is again that what you made 1 month ago. Who
Oh.
prevented you from filing it?
Holidays are there and this person is not able to come, my lords, because he's posted.
He's still posting in Howley, Lordship.
He's
still,
on Howley, but
he
not
is
getting-
still working at Howley,
Howley is
Lordship.
working, my lord. He's not getting leave, my lord.
House is also at Howley. House is also at Howley. For Dhubri.
Yes, my lord. Dubri, my lord. Wife is suffering from lupus, autoimmune disease
Autoimmune.
affecting the kidney, my lord.
Okay. Mr. D. Gogoi, the counsel for the petitioner submits that on account of the fact that the petitioner could not down to swear that he joined the affidavit, this same would not be filed. He prays that the said affidavit would be filed on or before.
My lord, I need at least 10 days, my lord.
On or before 31/7/2020. Registry to list this matter again on 7/8/2026. No further time shall be granted for filing of a rejoinder in demand by the petitioner.
There's an interim operation.
Interim order passed earlier to continue till the next date.
All right, my lords.
Lordship, records were called, we have the records.
What is the, have we gone through it?
Otherwise, yes, I could not go the full records. If the matter is fixed on a hearing day, Lordship, we'll have a full-length hearing. On a miscellaneous date is difficult.
Last date of admission?
My lord, the Tezpur University
Ah.
on the last occasion said that the last week of July, my lord.
July.
And
As
Monday,
per your-
Tuesday, or Thursday next, Lordship. Too many cases are fixed on Tuesday.
My only anxiety is that, my lord, if the process gets over for admission, then there will be difficulty. If they permit me on provisional basis to take the admission,
We'll have it on 21st. 21st would be would be convenient to you?
21st, too many cases are fixed that date.
No,
23rd,
I'll also be out of station. my lord.
23rd.
23rd?
And Thursday, my lord,
To have that.
uh,
We'll do one.
Then at Monday at 2 o'clock.
No, Monday 2 o'clock.
can it be, my lord, if not inconvenient to my senior, can it be on Wednesday, my lord?
Wednesday
At 2 o'clock.
2 o'clock.
Wednesday,
As agreed
Nice
to
study.
by the learned counsel for the parties.
Time may not be fixed, Lordship, we will do it.
Registry to list this matter again on 21. Huh?
No, 22. my lord.
22/7/2026. An endeavor would be made to dispose of the matter on the next date. Interim order passed earlier to continue till the next date of this.
Highly obliged.
Mr. Soikia,
Lordship.
he wants to do a course.
Yes.
Now, he did not apply. While applying for.
That is not the issue. The issue.
What is the issue?
Issue is there, Lordship. The thing is that if we have to give him study leave, then that particular course must be beneficial to our institute, number one. Number two, he was already given permission for study leave for earlier courses. During that time, the institution suffered a lot. Even now, a lot of works are pending, which is entrusted to him. So if he goes there and his course will require 6 months stay in the campus, which is not permissible.
6 months, that coursework thing.
Yes. In
That
campus.
is your basic area.
Basic thing. And the rule does not permit that. Rule permits study leave only in certain situations which he does not comply. And the law is well settled in this line, Lords.
Okay.
And he has conducted, there is misconduct on his part because in every stage, he did not inform the authorities with clean hands. The facts he tried to hide.
With regard to prosecuting in the.
Yeah,
PhD.
absolutely. So that equity will not go in his
Be
favor.
ready with your judgments also. both.
Yes, madam. Yes.
And if possible, if there is a list of books that can be given, if you.
Yes,
can
I'll
give
give.
Yes, yes.
Give it
yes,
the day
yes.
before, so I can also come prepared.
Yes, my lord, a day before we'll give, madam.
Highly obliged, Lordship.
Much obliged.
I am praying for one more week's time to file the
Why?
affidavit. And, just receive the instructions, madam. I'm just need some more time to prepare, madam. One more.
When did you retire, madam?
31/7/23.
20?
31st July to 23.
You're getting your provisional pension.
No, not at all. Not at all.
That is the impugn order. It has been withheld under Rule 22 of Pension Code.
This
Oh, that case.
my senior is in another court, so matter may be adjourned for the time being.
Is your senior Borbia?
No, not an HRA Soruri.
Where's the impugned order?
Page number.
It's 45, Mr. Botagut.
Yes, 45. So this impugned order was passed on which date?
48.
25, no? In the year
Oh,
25.
26.
26, and I was retired on 31st of July in 2023. For 2 years even I was not given the provisional pension, and then recently this order came out. But before this order even I was not given the provisional pension at all. So there were considerations and all.
Yes.
We have, my lord, received the entire instruction. Madam. Just one more week, I will file it, madam.
So in the last date also he was submitting this. So 1 month time was not enough for them.
No, Mr. Botagut. He retired in 2023.
Yes, sir.
And let us see that order we will examine. Withholding of pensions. We'll see. But from 23 to 26 on the date she passed the order, Rule 22, she's entitled to the back wages, to the what do you call that, provisional pension. Why was that not released? You passed an order in 25, no benefits have been given.
Some amount was released in between.
No, not at all. Not a rupees. No.
An order was.
Order was
I bought her, but Miss,
Borsa Boragodlu. I am the petitioner also.
you're the petitioner here.
But junior, no, but I am appearing on
Okay,
the.
ma'am, okay. Barsha Bora Bodle.
Yes.
Any other advocate appearing?
They were all, they are all Muslims. They have gone for the.
Petitioner in person.
Yes.
Third, Miss Barsha Bodle, petitioner in person, and also Mr. I. Bothakur, learned, standing counsel, excise department. Mr. Bothakur submits that an affidavit in the matter, that the instructions in the matter has been received by him, and the affidavit shall be invariably filed on or before 27/7/2026.
Okay.
Mr. Bothakur shall also on the next date of listing apprise this court as to why, shall receive instruction as to why, although an order dated 9/10/2025 was issued, authorizing to the petitioner a provisional pension with effect from 1/8/2023, the amount due thereunder was not released to the petitioner. Registered to list this matter again on 31/7/2026. Mr. Bothakur shall invariably file the affidavit in the matter as well as receive instructions with regard to the payment of provisional pension to the petitioner.
Yes.
Let's see next day. What?
Thank you.
May it please your lordship. Lordship,
Just a
okay.
Yes, madam.
Lordship, we have not received back the para-wise comment from the insurance company, Lordship. Lordship, may kindly allow us 2 weeks' time to file our affidavit.
Mr. Tabildar will be very happy with that. Heard Mr. A. Tabildar, learned counsel for the petitioner. Miss
K. Bora.
Huh?
K. Bora.
A.
Lordship.
Bora, learned counsel for the respondent submits that she be granted further 4 weeks' time.
Okay, Lordship.
4 weeks' time to receive instructions in the matter and file an affidavit. Pray accept registry to list this matter again after 4 weeks on a date to be fixed by. Interim order passed earlier to continue till the next date of it.
Obliged.
Mr. Tarbildar is the most happiest man.
Obliged, Lordship.
Yeah.
Lordship, in this case, I have filed an affidavit in reply.
Not on
To
record.
their affidavit in opposition, Lordship.
Oh, that is on record.
Lordship, may
On
kindly.
13 to 26.
Yes, Lordship. Lordship, may kindly see page 59, paragraph 4, Lordship.
Of the
Affidavit in reply. After filing of the affidavit of opposition, Lordship, these illegalities have come out, Lordship. I have given by serial number A, B, C, D, Lordship, next page 60. Lordship, may I read, Lordship? Firstly, the comparative chart enclosed with the affidavit in opposition has no specific dates and therefore has no evidentiary value. Undated documents lack legal validity and evidentiary value.
Okay, give
Often-
me a date. We'll have to hear it now. Finally, hearing day you give me. Whenever it's convenient to you. 30 is a 30 all of 9 purani. तारीख हुई से 100 ही हुई
23rd, Lordship.
20
23rd.
अभी possible
Then 28, then 28, Lordship.
28 to আছে নেকি আজি হল 3 তারিখের পারি 3 4 3 3rd.
Okay.
It is submitted that the pleadings in the matter is complete and the matter can be taken up for final consideration. Accordingly, registry to list this matter in on 8/2020. Mission.
Obliged.
None appears for the petitioner.
হেৰি আহিছে ইনষ্ট্ৰাকশ্যন আহিছে
A man died in 2001.
Yes, please.
Compassionate appointment. What is that? None appears for the petition. J.K. Goswami, done an edition. And Mr.
One.
Or done a standing council, public, whatever, standing council, what?
PWD.
PWD are present. So, be of the above, in, so the matter, there being no representative, matter stands dismissed or non-prosecuted. 2001. 1 minute. Yeah.
So for the assistant, he is coming to Guwahati from.
Oh. You are there. Then why are you standing there?
No, sir. So I contacted
Yes,
him.
where is Mr. S. Islam?
So he's coming to.
He's coming after some.
After 2 p.m.
Pass a detailed order. Call Mr. Islam. No timing today.
My senior is left in a mosque, my love.
Affidavits have been filed. You want encadrement of your post of data entry operator, right? How long have you been in practice?
2 years, my lord.
2 years. And the facts you should by heart. Read the facts, come back, 2 o'clock. Yes, Mr. Sinha, I got it.
Yes, my lord. The lordship will find at para 7, page 9. May I read, my lord?
Okay. Who is appearing for the respondents?
GSC, my lord.
Ms. Borua, are you appearing in this matter?
No, I am not appearing. Last order, Mr. B. Sharma's name was reflected Lordship, in
E. Sharma.
previous, Bidut Sharma.
Oh, very good.
Informed him, but
Ms. Sharma, Ms. Borua, the records are required. We'll have to ensure that the notices were issued to him and served upon him. Okay. Maybe the cause was issued to him.
yes.
But the inquiry having been ordered, the inquiry officer also should intimate him about the date of the inquiry, whether that was done. If that is cleared up, then he has a justified reason for being absent because he was under treatment and you had supported that treatment. Here, yes, Mr. Sama. Do you have the records of?
No, no, I have missed the case, my lord.
the case?
My lord.
Get the records. When can you get it?
Records, my lord.
Because I want to see whether the inquiry officer had issued any notice. Because otherwise, he met with an accident. He was incapacitated. And you had supported his thing. Bihar, AIMS, then you said, no, there will be a delay. You send him to Vellore. And all of a sudden, you institute a proceeding against him. So if this is unauthorized absence and it is for a reason which prevented his joining, he has a case. When can you produce the record? Give me a date wherein there will be no further adjournment.
My lord, my lord. But
Item
Mr. P.
MCP.
Sinha, London Council for the petition, also heard Mr. B. Sharma,
my lord.
CGC appearing for the
My lord.
for the purpose of appreciating the contexts raised by the petitioner in the matter, this court is of the considered view that a perusal of the original records of the departmental proceeding instituted against the petition would be mandated. Accordingly, Mr. Sharma submits that the records would be produced
My lord.
on
My lord. 10 days time, my lord.
give me a date that
My lord, my lord. 7th of August.
on 7/8/2026. So, Mr. Sharma shall also produce the records of, shall also ensure that the records of the inquiry held against the petitioner is also produced. So, for production of the records, the matter stands adjourned today. Registry to list this matter again on 7/8/20.
My lord.
Mr. Sharma, learned CGC shall invariably produce connected records. Yes.
Obliged. Thank you.
There is no representation. No, say. Mr. Islam, you are there in this matter, no? 4, item number 4. No, you are not there. Huh?
68 I am.
Passing with. Please. Person.
May I please, your lordship. Lordship may kindly come to the page 76.
Hmm.
The grounds
Hmm.
which have been cited. Revenue circle was evaluation sheet to be signed by chairman of the committee were not found. In some cases, 2-3 individual members had also not signed the evaluation sheet. No compilation sheet of evaluation signed by the chairman and member of the selection committee are found. So the viva voce was conducted, evaluation and compilation of mark were not done, and thus the selection process was not complete. The most of the committee members, including the chairman, who were government officials, have retired, and is practically not possible to complete the incomplete process with the existing record of interview, which are incomplete. Moreover, almost 6 years has elapsed.
So-
Is it the fault of the petitioner's lordship?
It's not your fault.
Not
We will never attribute any fault to you. But the thing is, now if we ask them to go and complete the selection process, if we pressurize Mr. Bhuyan will be bound to do that. But what is the sanctity of that selection process? There'll be no sanctity because there is no materials on the basis of which Mr. Bhuyan now can come
had a
to a
legitimate
conclusion that
expectation.
these are the selected candidates.
We had a legitimate expectation that the result will be declared.
We got it. We appreciate, accord approval to your legitimate expectation, but because of these reasons, the selection process cannot be, it'll be a farce.
Absolutely.
If we now direct the completion of the selection.
Then in WBC 3950/2021 at page 34, paragraph 3, upon instruction, MSRB Bora Learned Council for the authorities.
No, that time they were not.
Yes.
That inquiry was not done. This inquiry report came only on 26/11/24. What prevented you from coming immediately after the selection process to take forward your legitimate expectation?
Yes, we came.
You have not come, somebody else came.
No.
These petitioners have not come.
Yes. Deepak Narola and 10 others at page 30.
30.
3950 of 2021.
Same petitioners.
Yes. Here it is 15. In the present petition, there are 15, but in this 3950/2021, there were 10 petitioners. We came. Therefore, at page 34, the order the petition was closed.
Page 34.
Yes. Paragraph 3, upon instruction, Mrs. MSRB Board Learned Council for the authorities in the BTC has made a statement that a meeting will be held on 14/11/2022 and thereafter the result will be declared. In view of such statement, no further adjudication is required. So this was the submission submission before this honorable court that 14/11/2022 there will be a meeting. And no such meeting was held. Whether there was any meeting was held or not, let them produce. What was the outcome of that meeting?
But come to page 41, that was subsequently informed to this court. You had filed a second writ petition in the matter. In 23. The first writ petition is of 21.
21.
Then 23, you filed a writ petition.
Yes.
And therein it was highlighted before this court that the selection process is cancelled.
Cancelled.
And you were given liberty to assail that.
Yes.
Now, the present challenge is to the order of cancellation.
Yes.
Now, we'll have to decide on this, right?
Yes.
So you tell me, basing on these reasons, whether it is now permissible to direct them to take the selection process.
That should show us show this honorable court that the meeting held on 14/11/2022.
Forget 22 now. Forget 22. We are in 26. There is another.
We have been agitating since 2021. Selection process was complete.
Now you are all 54, 55.
Yes.
Yeah, but how can you be now even required to be directed to be appointed?
Some of them are eligible, will be eligible. Some of them.
Some of them,
Rest
if
of
the who are eligible will participate in the selection process.
But maximum of them will be
Sorry, my
uneligible.
sympathies are with you, but we cannot now direct them to take a illegal, this process.
At
That
least,
is
at least
clearly illegal.
Lordship may direct them to produce this meeting, minutes of the meeting of 14/11/2022.
That is gone in the second round of litigation. Anything more? Anything more?
That is my submission that this is not the fault of the petitioner because this,
We accept it
the selection
with-
committee has committed wrong.
with
Why should
all approval.
Why we should suffer, Lordship?
Unfortunate.
That is why
Unfortunate.
before your Lordship.
Unfortunate, can't help it. But with this material, I can't direct that. The selection process will have no sanctity.
If the selection,
If there is no materials basing on which the selection can be concluded, how can I direct them
if
to?
the selection would select list would have been published and if we would have not have come within a period of 1 year, then it's okay, fine. Selection.
Mr. Dhor, I got it. It is for these reasons. Now, tell me, how can I direct them to conduct a selection? To
No.
conclude that.
At the time of selection process.
What has happened
what has
happened.
prompted them? What has
Or what has happened has happened. Now, you have page 76 and the reasons there. Now, have you said any of, in your pleading, is there any pleading that these reasons are all perverse? Any material to show that these reasons are all afterthoughts?
No, that afterthought we have not said.
Then you have not brought even a single pleading to that.
I will come in.
With open eyes, how can I now direct? Because if I direct, they are bound to take it to the logical conclusion. What would be that selection then? Nothing. Yes, Mr. Vian.
Lordship, I have stated in paragraph 12. Paragraph 12 I have stated. Page 21. Sorry, page 12, yes, paragraph 12. The petitioner states that the respondent authority is without taking any lawful, rational or.
Now, writing these big words, manifestly flimsy, vague, legally unsustainable, that will not do. Where is the material? Or
No
where
material.
have you stated that these are wrong? These are available on record. These are available on record.
And paragraph 13 also I have stated that the
Okay,
petitioner
let us
states
see
that
what is paragraph 13.
the impugn cancellation order is
These are big statements without any basis.
Absolutely.
What is the basis for this statement?
The cancellation order itself is illegal.
The alleged absence of certain signature sheets, non-availability, so-and-so, retirement, and the mere are all entirely within the internal administrative domain of the respondents. Even these reasons, even if taken at face value, do not in law justify the cancellation. What more is required?
That's what it is. Admitted facts.
If you have better materials, withdraw this, come back. I have nothing to say. Otherwise, we are dismissing it.
Let me have a chance, Lordship. Let it come up on next Monday or Tuesday. Or on next day.
Heard Mr. Ardhor, Learned Counsel for the petition. Also heard Mr. A.K. Bhuiyan, Standing Counsel, Senior Standing Counsel.
Yes,
Bodoland Territorial Council, assisted by Mr. N.R. Sharma, Learned Counsel, Learned Senior Counsel, assisted by Mr. N.R. Sharma, appearing for the BTC respondents. Mr. Dhor, after arguing the matter at some length, submits that he be granted time till 24/7/2026 to further examine the matter and make his submissions with regard to the grounds assigned in the order dated 22/12/2025, cancellation earlier selection process wherein the petitioners had participated and which was not taken to its logical.
Lovely.
Accepted registry to list this matter again on 24.
24.
24/7/20.
Obliged.
Obliged.
Let him have his full satisfaction.
Yes,
Mr. Sharma. The doctor was supposed to,
Yes, he was there.
can you get hold of him?
PT Dutta Kuru. You want it? PT Accelerator.
Please, Your Lordship. This is last question, State Council took time for filing affidavit in this matter.
Forget your affidavit. Now you show me. Where is your application?
Application I have not annexed because minutes I have annexed page 12, Your Lordship. Minutes of the meeting, page 12. The case of there is a scheme for terrorist kill.
But that scheme is not there now. That scheme is gone.
Yes.
It's not there.
No.
No. Now it's compensation.
Yes.
The case was forwarded in 2018, page 15. And that ADC forwarded to executive forwarded to chief engineer, page 16. Page 16 can be resolved. Bottom, you are requested to kindly forward the same to the GOP for necessary approval of the appointment. License.
19. Compensation. As Gazier payment.
I said.
Scheme ko na order bajao to
Mr. Islam, this scheme was done away with in 2004, replaced by a scheme of compensation. That's all. Repealed by the government on 22/6/2004.
Direct dispose of the matter, direct the respondents to pay.
For that you appear. When did your brother,
Yes.
when did he, when was he
2001.
killed?
2001, 4/3/2001.
2001.
There are two items.
And when did you apply?
Might it is not mentioned because I have not found this application. That's why I have not mentioned.
So, your application date would be vital, but it's not there.
Yes.
Huh? What was your qualification at the time of
HSLC.
HSLC?
Yes.
At the time of application?
Yes.
So that is 2015. You passed your matriculation in 2015 only.
15 years.
So your date of birth is 1998. So you could not have applied before 2016. Huh?
Yes.
So this whole exercise is wrong.
This
right?
is considered
So,
2017.
Huh?
PNC considered 2017.
17, that consideration is no consideration in IR law because they were not empowered to consider that in terms of the policy. And if you had applied before 2001, that cancellation, 2004, then you might have had a case. But you were born in 1998 only, 4 years prior to the death of your father, brother. Now, how can that be? That will not be there. And if we direct, it will open up Pandora's box. That is against the policy of the government. These are policies of the government, not us. We cannot go into that. So do one thing. If you are entitled to compensation, claim that. Withdraw this, I will give you a liberty in accordance with law.
Dispose of then.
I'll dispose it. Okay. Heard Mr. S. Islam, Learned Counsel for it. Also heard Mr. J. Goswami, Learned.
On
Government
behalf of
advocate.
two lords, 2 and 4 lordship.
Also heard Mr. R. Dhar, Learned Standing Counsel.
1, 5 and 6.
Learned Standing Counsel, Public Works Department, appearing for the respondent number 1, 5 and 6. Why the PWD was taken? Was made a party?
Because
Minus,
he was in
his name was forwarded against the bill. Yes.
Also heard Mr. J.K. Goswami, senior, appearing for the respondents.
And
2 and 4. And Mr. R. Borpujari, Learned Standing Counsel, Finance Department, appearing for the respondent number 2. The petitioner in the present writ petition has raised, has prayed for a direction upon the respondent authorities for appointing him as a grade 4 employee on compassionate grounds under the provisions of the Assam Public Service bracket appointment of family members of persons killed by extremist / terrorist bracket over rules 1992. It is projected in the writ petition that the petitioner, that the elder brother of the petitioner, Sahab Uddin into Beleg, SK, was killed by unknown terrorist on 4/3, unknown extremists on 4/3/2001. So, a case pertaining to the death of the brother of the petitioner, a police case was registered, being support police station case number 3/2001. It is projected that the petitioner being eligible for being appointed against as a grade 4 employee had applied for appointment on compassionate grounds under the provisions of the Assam Public Service Act rules to 1992, hereinafter referred to as the rules of 1992. And his case was considered by the district level scrutiny committee in its meeting held on
30/11/2017.
30/11/2017. So it is further projected that a recommendation was made in favor of the petitioner for appointment on compassionate grounds in terms of the recommendation made in this connection by the district level committee. And the matter was forwarded to by the executive engineer PWD, Dubri, AACP division to the chief engineer roads. However, no further steps having been taken in the matter, the petitioner has instituted it. I have heard the Learned Counsel for the parties and perused the materials available. At the outset, this court notices that the present writ petition is not instituted praying for appointment on compassionate grounds under the scheme in vogue in the state for appointment of the next of appointment of the relatives of government servants who die in harness. The present writ petition has been instituted claiming such appointment by the petitioner, who is the brother of a government servant who was killed by extremists on 4/3/21 by invoking the provisions of the said rules of 1990. Also, the submissions of the the learned counsel for the respondents have submitted that the scheme for appointment of persons killed by extremists under the provisions of the said rules of 1992 was done away, was stopped on the said rules of being repealed on 22/6/2004. It is submitted that applications received prior to repeal of the rules were being considered. It is further projected that after the repeal of the 1992 rules, the members of the family of the person killed in extremist violence was being extended with monetary compensation. Also, the rules of 1992 being repealed on it is to be seen as to whether the application submitted by the petitioner was so submitted prior to the repeal of the rules and a repeal of the rules. The brother of the petitioner is projected to have been killed by extremists on 4/3/2001. The petitioner in the present writ petition has brought on record his matriculation certificate, and therein his date of birth has been reflected as 1/1/1998. Accordingly, the petitioner cannot be expected to have submitted his application before attaining the age of 18 years, which he had attained only in the year 2016. Accordingly, the application submitted by the petitioner admittedly was not so submitted prior to the repeal of the 1992 rules, that is prior to 22/6/2024. Accordingly, in terms of the policy decision adopted by the government in this connection, the application submitted by the petitioner would not have mandated any consideration under an already repealed rules by the district level scrutiny committee in its meeting held on 30/11/2017. Accordingly, the recommendations made by the district level scrutiny committee, including for the appointment of the petitioner against a grade 4 vacant post, is found by this court to have been so made without any jurisdiction. Accordingly, the claim, in view of the above discussion, the claim made by petitioner in the present stance would not mandate an acceptance, and accordingly, the writ petition is held to be void of any merit, and the same stands dismissed. However, dismissal of the present writ petition would not prevent the family members of late Shahabuddin Sheikh to approach the respondent authorities for being authorized compensation for his death on account of extremist violence, if such compensation has not already been authorized to the family of late Shahabuddin Sheikh. The instructions furnished by Mr. J.K. Goswami, learned additional senior government advocate is kept on record and marked as X for the identification.
Published.
Yes.
May I please, listen, my lord, this case relates to the calculation of his seniority, my lord, from the date of his initial appointment. However, my lord, during pendency of the case, my lord, it was been observed by the honorable court that any appointment made shall be subject to the outcome of the writ petition. But, my lord, on 22nd 5, my lord, they have 4 number of private respondents have been promoted.
That will again be subject to some of this question.
But it's not mentioned, man.
Need not be. It's mentioned. Where is the order? Which
Lord,
order it is mentioned?
The order to DS. It is there in the order sheet, man.
Where?
For sheet.
Any decision taken on the basis of the gradation list in question shall be subject to the final order that may be passed in the connected. That is in the IA.
IA, my lord. But without considering that, my lord,
Okay, what is your case?
my case is that, my lord, petitioner was initially appointed as a data entry operator.
The private respondents have come.
They have filed their affidavit, my lord. I have received the copy.
So you are a data entry operator.
Initially.
Hmm.
Thereafter, I approached to the authority, my lord. Since the data entry operate single post, there is a provision, there is no
Promotional
any
avenue.
promotional avenue.
Hmm.
Thereafter, my lord, I was been subsequently I have been allowed as a junior assistant.
Where is the order?
Lordship.
You have been absorbed as junior assistant.
Yes, my lord.
Where is the order?
At page 36. Serial number 3, my lord. Seniority of the Kendra Kalita may be fixed at the bottom of the interstate seniority of the junior assistant office of the chief engineer. This is the impugned in my instant case also.
So your seniority, then when was the order passed? Redeployed as so and so. So your seniority counts from 29/5/23.
23.
Okay. So now where is your placement? Serial number 6.
My lord. There is
Page
a
39.
initially lordship kindly have a look, page 45. My name stands at serial number 22. Thereafter, again, my lord, my name appeared as serial number 24. During that time, my lord, a decision was
Where is the seniority list of junior assistants? This is the amalgamated cadre. You are in the cadre of junior assistant. You are 1, 2, 3, 4, 5, 6.
And my lord, thereafter, page 57. This is also impugned in the instant case. My name has been shown as serial number 4. Serial number 4. And impugned speaking order that your lordship will see at page 61. Paragraph, last paragraph. And whereas the order passed
by the Honorable High Court judgment passed in WBC number department decided to follow.
Page 61.
61 is the another case, my lord, similar situation, my lord, how
Forget
seniority.
that. You show me your case. Where is the speaking order in your case?
That is otherwise only two things I have challenged, my lord.
So what is the mistake there?
Mistake, my lord, that did not count me from my initial appointment.
It did not be, you have accepted, have you challenged that?
Yes, I have challenged.
Where? When?
It is the instant, the prayer portion, lordship.
No, wait one thing. This is an order of 23.
23.
Ah.
I challenged by the instant writ petition in
Where?
24. I made a prayer, my lord. Lordship will see at page 23. Setting aside and quash the Impian interseat seniority list of junior assistant so and so under whereby the seniority of the place serial number 4. Number B. Seniority shall not be issued, setting aside and quash the impugned communication dated so and so page 36. That is I put under challenge, but PhD department has not filed.
Your challenge to that condition number 3.
3 only.
Where?
Yes, my lord, it is there, page B, my lord. Shall not be
Mr.
satisfied and
Bormia,
quash
you better come with full preparation.
I am prepared. my lord.
J.I. Bormia, learned counsel, heard Mr. J.I. Bormia, learned counsel for the petition. Also heard Mr. I. Borthakur, learned standing counsel, PhD. As agreed to by the learned counsel for the parties, registered to list this matter again when? 6/8/2026 for admission here.
In the
You
meantime,
come
my,
up with the decisions as to why that condition is wrong.
my lord, that I'll come back.
Amalgamation.
But they have not filed any affidavit, my lord.
That is, you take advantage of that situation.
Nahi kora. Nahi kora.
You take advantage of that situation.
Yes, ma'am. Now, it's a private respondent of this.
Yes,
Yes,
but-
now, private respondent. It is Diana hai. Oh, is that-
Yes, Mr. Das.
I feel affidavit in reply. Filed by the respondent 3 and 4 for our files. They are also filed in affidavit in opposition. My lord, the petitioner, case 8, report, he made with an accident 12/12/2010 at Bhatnabari Bazar while he was going to his house had sustained grievous injuries on his person. He was under treatment from the date of accident, that is 12/12/2022, 31/1/2011. Whatever PSC, whatever, and then he go to Gauhati Medical College and Hospital at Gauhati for medical treatment, where he took treatment. My lord, my medical certificate is page 48, page number 48. My lord, afterwards, my lord, my lord, page 12. Page 12.
Justify the delay.
My
14 years in challenging the.
my lord, after getting my disciplinary inquiry order, dismissal order, I engaged an advocate, Abdul Malik.
You moving.
My lord, unfortunately, the advocate, Abdul Malik, in my repetition, it is.
Have you made him a party?
Huh?
Have you made the advocate a party here?
It's fine, my lord, Abdul Malik.
Found out some people expired.
Expired, my lord.
Not entertaining.
And I was engaged. I made an RTI application. My lord, the order, the dismissal order, it is, my lord, it is, my lord, it is contradictory, my lord. My lord, because I never filed any read petition before the Honorable Court. In the order, in the dismissal order, page 60, my lord, it is said that the Honorable High Court, reinstated me again. As such, I filed an RTI application before the concerned department, we respondent number 4 and RTA reply, my lord, page 65, my lord. It is, kindly see, my lord, page 65, my lord. RTA reply. Refer your RTA application dated regarding information sought by you. I am to inform you that the out of information available in the course contains 20 pages.
How will they know that after 14 years? How will they know what records are there, what records are?
The affidavit reply filed by the respondent 3, my lord. In an affidavit in reply, it is replied. Affidavit in reply filed by the respondent 3. It is answered, my lord.
Where? Tara?
Filed by and repetition also it is replied. Para 5, page 91. Repetition. 91. That with regard to the amendments, like a 4 of the opposition, the different begs to state that auto Lavendra Sarkar submitted an appeal before the appellate authority, coming Inspector General of Police, Sulubari, against the order of the disciplinary authority of. In regard to this, it is reflected, my lord. It's right. It is reply, my lord, para 5. In regard to second para of the para 4 of the affidavit in opposition, we humbly state that after having received of the improved dismissal order dated 1/10/2000, the petitioner engaged an advocate tested with regard of the case, but unfortunately he expired. Thereafter, the petitioner made an RTA application on 7/12/2023 through his newly engaged advocate regarding his service and improved dismissal order, and received RTA reply on so and so, respectively, thereby stating that the information sought in the RTA application available in the records containing 20 page copies for which the applicant have to pay the cost.
So, you were fit for duties on 4/4/2011. Why did you not join thereafter?
My lord, kindly see in the para of the petition. I come to the join.
What is your case?
Yes, Lordship, in paragraph 6, Lordship, in my, the affidavit running page 70, Lordship, that that the statement of the petitioner come to learn about the proceeding drawn against him only when he was ready to resume duty on 7/04/2011 and had not received any notice prior to drawn of his proceeding. Denying the fact, the deponent begs to state that the following notices, reminder notices, were served through OC.
That is gone. He filed his written statement. That is the end of the matter.
Yes, Lordship.
Yes, Mr. Das. Oh, you were fully aware of the proceeding.
Lordship.
You were fully aware of the order. You did nothing. We'll dismiss this. Help it.
My lord, kindly see page 14, para 14. That the petitioner begs to state after having received a set order, the petitioner no. My lord, I have completed 20 years of service, my lord.
You have a history of misconducts. Heard Mr. Adas Leonard at some length. So that Mr. Take goes on. Hearing body. All the hearing remains. Registry to discuss matter again on 18/8/2026 for further hearing.
Lords,
Pass the orders on that.
Lords.
You have something developed.
On which day, my lord?
18/8.
My lord, the order is contradictory, my lord.
Yes, you're correct.
So I file RDA decline.
If you just prepare nicely.
Oblige, my lord.
Yes. Lord, last occasion, my lord, record was called for.
Receive record, right?
It is submitted, that the pleadings in the matter and the records in original have also been released, have received accordingly. The matter, it is submitted by the Learned Council for the parties that the matter can be taken up for final consideration. So, accordingly, registry to list this matter again on when?
In August.
What date may be given?
11/8/2026.
11/8.
For admission here.
Oblige.
May I please, your lord?
Here, similar matters has already been dismissed by the coordinate bench, lordship.
But here in the
Hesitation marks.
case, here in the case is
I
that your,
dismissed a
yes,
few matters.
Yes,
my
lordship.
case is that your lordship, on the ground of hesitation, cut mark, his candidature was rejected.
There are
But
decisions.
yes, but the doctor opined that no such psychiatric. Lordship kindly, page 56 of their affidavit, your lordship kindly see. They are still admitted. Page 56. Page 56, para 5, your lordship. The psychiatric consultant, after required examination, your lordship got it.
No, at that
Opi-
point of time, you did not have. But the hesitation cut marks that you had
No, no,
reveals that you
hesitation
may
cut
have
mark.
a
Yes, I have the hesitation
Mr.
cut mark.
Counsel, you are recruited to an armed force.
Yes.
You must be clear in all respects. Otherwise, you will be a danger to the society. That's the only reason. And once a review medical board had come to a conclusion, that is final. Supreme Court has said.
But that decision, your lordship, is the decision of the review medical board, your lordship. Nowhere the doctor
And
opined.
see, once you are inside the force, you will be subjected to immense pressure. These things can then again resurface. Why take a risk?
But that view was not taken by the doctor who examined the petitioner, your lordship. And the doctor
Review
who
medical
examined the
board,
petitioner,
review medical board took into consideration GMC opinion and then came to its own
Yes.
conclusion.
Yes,
That's
the opinion of the GMC, your lordship, nowhere that mark is there, your lordship. My case is that, your lordship.
Okay,
That
we'll consider.
the superseding the opinion of the doctor, your lordship, the
But
review
the
medical
Learned
board
Counsel
passed
for the
that order.
parties at some length. Hearing remains inconclusive. Registry to list this matter again on 28/7/2026. I'll pass the orders on.
Kindly it will.
29, 30.
I am not available.
When?
30.
30.
30, your lordship, then on 2, your lordship.
30. You need not be here. Nobody should be here. I'll pass the orders.
Oblige.
For delivery, you need not, nobody should be here. On
But
28,
in one case, your lordship, in similar type of case, your lordship, the re-examination has been given, your lordship.
the examination given to you, the re-medical board given
No,
to you.
after.
I have passed orders in this court. There are coordinate bench judgments. There are Supreme Court judgments.
Yes,
I'll incorporate those. I'm not carrying those today. I'll incorporate.
Oblige.
May I please, your lordship? Petitioner candidature has been declared unfit, my lord, on the ground of dental point less than 14, my lord. Now kindly see, my lord. Calculation, my lord.
Okay. It is submitted that they will have to examine this. Proceedings in the matter is complete. Please wait to list this matter for,
What date, my lord? Next
the
week,
matter can be taken up for final consideration. Please wait to list this matter again on 13/8/2020 for admission here.
13, my lord. Can it
One
happen?
week. Fixed up. 13/8 will.
Obligement.
So in this case, I am appearing for Oil India. My assisting counsel, he is not available today, Anshuman Sharma.
Oh, you have a better, you have Mr. Kolita
Yes,
with you.
but I want a formal one, Lordship. So can it be taken up next week, subject to this only?
Is that,
There is some urgency on my part.
railway?
This body, yes,
Railway. Yes,
my lord.
Lordship, I've given the NSC, Lordship.
you have given the NOC.
Lord, what happened now is that after all the litigation before tribunal, my lord, OA, contempt, then writ petition by railway before the Honorable High Court, they have released me. Now, after the release order, my lord, I have submitted the release order before the Oil India Authority. Now, they are not accepting my appointment. Rather, they are contesting that.
And Mr. Soikia will have to be given an adjournment today because he is without
On
his.
Monday, it can be taken up, Lordship.
Monday would be difficult.
Then Wednesday, Lordship.
Wednesday.
Wednesday, you're that matter I have fixed.
Yes.
Along with this, I don't think this is a
No,
very
you
long matter.
both will go bombard me and I'll have.
No. This is a very simple matter, my lord. Only question remains whether
Simple
oil can
matter
refuse.
when Mr. Das, Mr. Soikia is appearing.
Lord, when I am appearing, it is simple.
And when Lordship is hearing.
Jalebi.
No, Lordship, when Lordship is hearing also.
I'm here.
Yeah,
Now
then
the fact
it
has,
will,
my lord,
we may not know.
He has given it back to me.
now facts are in a very narrow campus, my lord. After the release,
On Wednesday, Lordship.
Mr.
he's a poor
Wednesday.
boy, my lord.
We'll take a try. As agreed to by the Illinois Council for the parties, registry to this matter again on 22/7/20. Board revision. Huh?
At two,
Mr. Soikia, on that day, these two matters, if required,
Yes.
there is urgency. Kindly make a mention. Ask your junior to make a mention.
Lordship.
Both of you.
yes, my
At
lord.
a
Only
particular time-
what is, that's why I said that no time may be fixed on that day. Because one very urgent matter is fixed in the
No, we understand.
in the district court. The date has to be given today. On
Mr.
15th, the
Soikia,
matter was there.
We are here till 4:30.
Yes.
As for your
Yes.
convenience,
That
whenever
day-
it is there, just ask your junior to talk to
Yes.
Mr. Das, come back.
Yes,
If required, Lordship, we'll take a, maybe at the very beginning also.
You can make a mention.
Lordship.
no, we'll confirm the date from the senior and we'll.
You have
I'll know my position this evening only.
Yes.
Mr. Soikia, no issue. We are here the whole day. I don't want you to wait. If you come, give me a time so that I can also finish off the other matter.
Lordship.
Fine, my lord.
Highly obliged.
Deeply.
The format.
May I please roll on?
Mr. Das.
My case may be placed on the DLC, my lord.
Yes, what happened?
It is a communication. Yes.
Yes. Your case has been placed before the DLC.
Maybe please,
Maybe.
maybe please, with the details, my lord. I communicate Sri Ashok Kumar Boroman SCS, Director of Annual Husbandry, as per order dated 6/12/2017, passed by the Honorable Gauhati High Court in WBC Nung 7521, 2017 versus C. Judician versus C. State of Assam and C. Others. The order dated 4/10/2020 passed by the Honorable Gauhati High Court in contempt case number 65/2009, and order dated 29/1/2004 passed by the Honorable Gauhati High Court in IAC Nung 3797 2027. I already intimated my lord. My lord, Ashok Kumar Burman, SCS may be implemented at the container. And
Who is appearing to
Yes,
the
sir.
respondents? Animal husbandry and veterinary.
The standing council, animal husbandry and veterinary is reflected in the cause list. But Lordship, although Lordship, the earlier director, he was he has changed, Lordship. Now the director is new.
Okay, ask your director to be here.
Lordship.
Now orders have been passed, not complied with. Why?
Lordship, that I have to take instruction because
Or is that something which requires understanding of a rocket science? Only case was place the matter before the DLC. That's all.
Lordship,
What happened? That
no,
much
no, I will,
instruction you all can give me.
I will pursue the
Mr.
matter.
J.K. Goswami, Learned Council, Learned Standing Council.
Animal husbandry.
Animal Husbandry and Veterinary Department is requested to receive instructions from the concerned authorities as whether the case of the petitioner was placed for the district level scrutiny in terms of the directions passed by this court by order dated 6/12/2017 in WPC number 7521/2017. Mr. A. Chakraborty, learned government advocate, is also requested to receive instructions from the Deputy Commissioner, District Commissioner, Baska, as to whether this jurisdictional district level committee had considered the case of the petitioner after the passing of the order, said order dated 6/12/2017 by this court. Registry to list this matter again on 14/8/2026. On the next date of listing, the respondent shall invariably furnish the requisite information in in response to the queries raised by this court to the respective councils, to the Standing Council, Animal Husbandry and Veterinary, and the to Mr. J.K. Goswami, Standing Council, Animal Husbandry and Veterinary, and Mr. A. Chakraborty, Learned Standing Council, Learned Government Advocate.
A copy may be furnished, Lordship.
copy hasn't given 2 marks, my lord. I will send. I will.
Now you take that copy of the order and then.
Yeah, I will.
Made, please to your lordship. Lordship, kindly peruse the order dated.
Yes, we have communicated and served the copy to the respondent number 5.
Yes, madam.
Yes, we have served the copy.
On
through-
respondent number 5.
On, yes, and
Where is the report with regard to this service from
yes,
respondent?
received copy of the Hemavati Devi's.
As Borough Government Advocate submits that the notice pertaining to the pendency of the present proceeding has been served upon the respondent number 5 by the Child Development Project Officer, Raja Bozar ICDS Project, Kacha, on 27/6/2026. Also, a report in this connection received from the Child Development Project, CDP, Raja Bazar ICDS project is placed on record. So, is furnished, full stop. The said report is kept on record and marked as purpose of. So accordingly, the service of notice upon the respondent number 5 is held to be registered to list this matter again for admissions on after.
Lordship, kindly fix a date.
On 3/8/2020.
There is Lordship interim order.
Interim order passed earlier to continue until the next date.
Highly obliged.
This case, my lord, review petition was dismissed on 14/7, my lord. Therefore, I am paying for some time for compliance of the order, my.
Oh,
That-
yes. That repetition was just filed. Review petition.
Review petition, my.
When are you implementing?
My lord, some time may be granted, my lord.
How much time?
After 3 weeks, my lord, any day.
If you can file, you know everything, you know the review petition also.
My lord.
What is more required? You know what is to be done?
After 2 weeks, my lord, any day.
1 week. On 31. Ms. S. Chutia, learned counsel for the learned counsel appearing for the heard Mr. M. Dr. Learned Chief appearing for the petition. So heard Ms. S. Chutia, learned counsel appearing for the respondents. Ms. Chutia submits that the review petition referred against the order dated 10/6/20, judgment and order dated 10/6/2020 in WPC number 2601 was dismissed by this court on 14/7/2026. Thereafter, the respondents are processing the matter for appointment of the petitioner. So accordingly, she prays that she be granted time till 31/7/2026 to apprise this court about the further developments taking place. It is directed that the review petition having been dismissed, the directions passed by this court by judgment and order dated 10/6/2024, WPC number 2601/2023 is to be expeditiously implemented by the respondents. Accordingly, the respondents shall take all requisite steps for compliance with the directions passed by this court, violation of which is alleged in the present on or before the next date of registry to list this matter on 31/7/20.
Lordship, petitioner was suspended on 38/11/2024. Last occasion, they took time.
In this matter, we have been implemented on the last occasion, my lord. I'm awaiting my instructions, my lord, in this matter, my lord. We have been implemented, my lord, on the last occasion, my lord. And my lord, we have written to the Deputy Commissioner's office, my lord, since they are the appointing authority.
Your suspension is of which date?
Date 38, losses page 20. 38/10/2024.
First time.
And would have reviewed that again, Deputy Commissioner passed an order that is page 28 on 3/7/25 until further
You
order.
granted bail on?
Bail, my lord.
Bail on?
It's 11. কেতিয়া আছিলে ইয়াতে লেখা নাই নেকি your service পেৰা আছে ন registered case submitted dates are sent to me. লিখিলো নেকি On 28/10/2024, petitioner was arrested, my lord.
On
28/10/2024. And on 29/10/2024.
when were you bailed out?
Yes, my lord.
10/12/20.
10/12, yes. After that, we have submitted the reply, proposed reply.
26/12.
26/12.
26/12/2024.
Yes, what is the error in this?
My lord, 90 days.
Were behind bars.
Yes.
In terms of the decision of this court, only after your bail, 3 months time. Even before that, they have. Yes, what is your instruction?
Lordship, my instruction is that, Lordship, as per the OM, as per the government letter dated 27/05/2024, the inquiry report need to be forwarded to the obtain of the approval of the Chief Minister Office through the General Administration Department, Lordship. That's why, Lordship,
You
on
have forwarded the
yes,
inquiry report
it was forwarded,
to
Lordship.
Mr.
On,
Fugan.
yes, Fugan, on 28/05/2024, Lordship.
20.
27/05/2024.
Until date, the
Lordship,
inquiry report.
no, Lordship, that was forwarded to the General Administration Department.
In 24.
No, Lordship, no. That was subsequently. That was that date is not reflected, but it was forwarded, Lordship.
When?
That date. Yes. Report was forwarded to the General Administration. Lordship, regarding
As prayed for by Mr. A. Fukan, Planning Council, General Administration, and Mr. J.K.
no,
Kusam.
that was on 22/08/2025, Lordship.
22.
That was received by the report of the inquiry committee was received on 22/08/2025 by the
GAD.
Commissioner Secretary to the General Administration Department, Lordship.
Then we have to know what they have done.
Yes, Lordship.
Mr. Fuk, you have not received.
Actually, we have been implemented on the last occasion.
Fine, you have.
I'll get my instruction.
Mr. A. Fukan,
But there is an order.
Planning Council, GAD submits that he be granted time till 29/7/2026 to receive instructions in the matter as to the steps taken after the inquiry report Proceeding Institute was forwarded to the General Admin. Right? Right?
I'll get it.
Mr. J. Handick, Learned, Standing Council, Revenue and Disaster Management. A registry to list this matter. 29.
29.
History of which?
Tab 29.
Yes. Mr. Chaudhary.
Yeah, page Lordship. My lord, on the last occasion, it was directed to go for the appellate forum. But the organization has not yet notified any appellate forum.
Yes, madam.
My lord, I have only been recently engaged in the matter. I'm yet to receive the signed copy of the Wakalatnama. We'll file it tomorrow or at the earliest by Monday.
That is your headache, madam. We had issued notices on 12/6. Huh?
I've only been recently engaged, my lord. Please allow me a week's time to.
Where is the order of the ICC?
Instructions.
The order of penalty is annexure 5, page 114. Annexure.
Huh? ICC? Where is the report of the ICC?
Report is annexure E, page 46.
46. 06. Where is the conclusion?
Conclusion, my lord. See, use report.
Madam, 1 second. Let us just have.
Conclusion is at page 100. Recommendations and disciplinary action, substantive findings and all.
And then directly penalty.
Yes, madam.
How?
I have to obtain
That
instruction.
is why I am waiting for a filing appeal.
No. Your appeal is gone. ICC report, how can, why appeal? ICC report has already been implemented.
But there is no appellate forum. Within 90 days.
Next second, PROCEED to some.
Rule 18 says, my lord. Actually, my lord, there are several causes. It is not actually a sexual harassment. This is a normal harassment. Other harassments. They have directly placed it under ICC under POS. Just because the complainant is a lady.
Has the ICC determined any amount to be recovered from you?
Yes, my lord.
Much, 50,000.
ICC has given 75,000.
But the 50,000 was.
Yes, penalty is 50,000. And in the earlier order, it was directed that any amount so deducted shall be subject to the outcome of the writ petition.
Madam, you are for the Assam Gas Company.
For respondent number 1 and 2, my lord.
Assam Gas Company. Now, you get a report and the recommendation therein indicates him. The misconduct is proved. Now, you will have to move against him in terms of your departmental proceeding rules. Can you directly impose a penalty?
Your Honor, you're absolutely right in that.
Okay, Miss.
But I would have to obtain instructions, my lord. M. Das here.
Miss M. Das, learned counsel submits that she is under instructions to appear in the matter on behalf of the respondents number 1 and 2. She prays that she be granted time till.
Let them file a reply, my lord.
7/8/2026 to file a response to bring on record the stand of the respondents represented by her by way of filing an affidavit. Prayer accepted. Registry, prayer accepted. Registry to list this matter again. 7. List this matter again on 17/8/2026. The respondent number 1 and 2 shall invariably file their response on or before 7/8/2026. The petitioner is permitted to file a rejoinder thereto on or before 14/7/2026. Will do. 14/8/2026. Registry to list this matter again on 19/8/2026.
Deeply
File
obliged.
it. Yeah.
The entire selection was cancelled. In fact,
Entire
thereafter,
selection.
yes, thereafter fresh advertisement was made, my lord, that is also over.
That is
Already over. my
Over.
lord. It's a
In that
downside.
case, I have an alternative prayer before your lordship. Lordship, if any post will be advertised in near future, my lord, I may be given the weightage, my lord.
Oh, what weightage?
What
you want?
it is, yes, my lord.
I am
have you
already
worked?
discharging my duties in that establishment, my lord.
That for that
Temporary.
you come up with a different plea. Here we cannot do it.
In that case, whatever your lordship may be.
For that, this is only with regard to the selection we will be interfering. Nothing else. But Mr.
As to by them.
As Upadhyay, learned for the petition. Also heard Mr. B. Gogoi, learned additional advocate general appearing for the state respondents. The petitioner in the present petition has presented a challenge to an order, to a communication dated 27/7/2017 issued by the Secretary to the Government of Assam Health and Family Welfare Department, cancelling the selection initiated against grade 3, cancelling the recruitment process initiated against grade 3 and grade 4 posts at Tezpur Medical College and Hospital in pursuance to an advertisement dated 18/6/2015. Also, the petitioner in the petition has contended that in pursuance to an advertisement dated 18/6/2025, inviting applications against post initiating a recruitment process against various posts, against various grade 3 and grade 4 posts, including the post of
Attendant.
In the available in the establishment of the in the Tezpur Medical College and Hospital, Tezpur. The petitioner had submitted its candidature against the post of attendant. It is further contended that the petitioner had appeared in the selection process and basing on his performance therein, the petitioner was confident that he would be selected his name would figure in the select list. Was a viva was he held? No.
Yes.
Select list. However, the results of the set selection process was not completed. Also, next. Persons similarly situated like the petitioners. Petitioner here, no? Only one petitioner.
One petition.
Yes.
Like the petitioner herein had approached this court by way of instituting a writ petition being WPC number 924/2016, raising a grievance with regard to the delay occasioning in taking the recruitment process initiated in pursuance to the advertisement dated so and so to its logical conclusion. So, a coordinate bench of this court-wide order dated 23/6/2016 was pleased to dispose of the said writ petition, directing that the selection in question be taken to its recruitment in question be taken to its logical conclusion within a period of 2 months from the date of the order. Also, it is projected that after the passing of the said order, the recruitment process which was stalled was again started, and the petitioner had appeared before the selection committee in the viva voce scheduled in the matter. However, the selection was thereafter not taken. However, no select list came to be published in the matter. No select list was published.
No.
Also, it is at this, it is in the above situation that the Secretary to the Government of Assam Health and Family Welfare Department proceeded to issue a communication dated 2017, cancelling the recruitment process initiated for cancelling the process initiated for recruitment against grade 3 and grade 4 posts in Tezpur Medical College and Hospital. Also, being aggrieved, the petitioner has instituted the present writ petition. Mr. Upadhyay, learned counsel for the petitioner, reiterating the facts noticed herein above, has submitted that the selection process having proceeded to its last stage and candidates being permitted to take part in the said selection process, the petitioner having also participated in the viva voce segment of the selection process, the respondent authorities could not have kept the matter pending, causing prejudice to the petition. It is submitted that the selection process was mandated to be taken to its logical conclusion, and in the event the petitioner was within the merit position mandated for appointment in the selection process, mandated for appointment against the post of attendant, he was required to be issued with an order appointing him in against such post. It is submitted that the respondent authorities had published select lists with regard to certain posts. However, the select list for against the posts available for attendance were not so published. Mr. Upadhyay has further submitted that the reasons assigned by in the communication dated 27/7/2017 would not mandate a consideration, would not mandate an acceptance, inasmuch as the said reasons are vague to the core of it and cannot be relied upon for the purpose of cancellation of a due process of selection initiated by an authority competent to do so. In view of the above, the above premises, Mr. Upadhyay submits that the order dated 27/7/2017 would mandate an interference from court with a further direction to the respondent authorities to take the process as initiated, selection process as initiated in pursuance to the advertisement dated to its logical conclusion and effect appointments against the advertised posts on merit. Mr. B. Gogoi, learned counsel for the respondent, by referring to the communication dated 27/7/2017, has submitted that the selection process initiated, the recruitment process as initiated by the principal of Tezpur Medical College and Hospital, Tezpur, was so initiated without receiving a prior approval for the same from the government. He submits that an approval was mandated to be received from the finance department before the posts in question were put up for recruitment. However, no such approval is found to have been so received prior to issuance of the advertisement in question. Mr. Gogoi further submits that that in the manner of recruitment as initiated by the principal as initiated by the principal of Tezpur, Tezpur Medical College and Hospital, the provisions of the Assam Public Services direct recruitment to class 3 and class 4 and 4 posts rules 1997 was not followed. Accordingly, it is submitted that on a review of the matter, the government in the Health and Family Welfare Department proceeded to cancel the selection recruitment process as initiated while the advertisement dated so and so. Mr. Gogoi, on instructions, further submits that the posts involved were thereafter put up for recruitment, and on conclusion of the process of recruitment, the said posts have already been filled up. Right, Mr. Gogoi? So I've heard the learned counsel for the parties and peruse the materials available on record. It is the contention, it is an admitted position that the petitioner hearing had submitted his candidature for the post of attendant dissection, that na total.
Yes.
Attendant bracket dissection, central photography, some audio-visual unit, comma, central workshop in pursuance to an recruitment process initiated for the said post wide issuance of an advertisement dated 18/6/2015. The petitioner had qualified in the written examination segment of the said selection process. However, the selection was not taken forward thereafter, although the petitioner contends to have qualified in the written examination segment of the selection process. Person similarly situated like the petitioner had approached this court making a grievance with regard to the delay occasioning in conclusion of the selection process initiated in pursuance to the advertisement dated 18. So, a coordinate bench of this court noticing that during the pendency of the case, the results of the selection written test were declared on 21/5/2026, and a viva voce examination was also completed, proceeded to dispose of the writ petition with a direction to the principal cum chief superintendent, Tezpur Medical College Hospital to take immediate steps for declaration results. Also, the results not being declared, it is seen that it is projected by the petitioner in the writ petition that the declaration of results was done selectively against certain posts put up for recruitment, while the advertisement dated so and so. However, the select list for the post of attendance as put up for recruitment, while the said advertisement was not declared. Also, being agreed, it is at this stage that the respondent that the government in the Health and Family Welfare Department on a review of the recruitment process as initiated in the matter by the principal Tezpur Medical College and Hospital for filling up the vacant posts of grade 3 as available in said institute, having found that the selection was not so initiated after the approval in this was received from the government in the Health and Family Welfare Department, and also after an approval for the same was so accorded by the Finance Department, Government of Assam. The stand of the respondents is that the selection process was unilaterally initiated by the principal Tezpur Medical College and Hospital without there being a sanction for the same from the government. Accordingly, it was further projected by the respondents that the selection process was so conducted in clear violation of the provisions of the Assam Public Services Rules 1997 and also the Assam Fiscal Responsibilities and Budget Management Act 2005. In the said premises, the government had arrived at a decision to cancel the selection process This court had, next, this court had raised a query with Mr. Gogoi, learned additional advocate general, as to whether the cancellation was done selectively for certain posts and or the such cancellation was against all the posts put up for recruitment while the advertisement dated so and so, 18/6/2015. Mr. Gogoi on instructions has submitted that the cancellation as the decision to cancel the recruitment process was so applied, was applied to all the posts put up for recruitment while the said advertisement dated 18/6/2015, right? So, in view of the above stand taken by the respondent authorities and reflected in the order in the 7/7/2017, and further the said policy decision, the said decision being applied to all the posts put up for recruitment while the advertisement dated 18/6/2015, this court is of the considered view that such a decision taken, policy decision taken by the respondents would not mandate an interference from this court. It is, this court also notices the submission made by Mr. Gogoi that the post put up for recruitment while the order dated, while the advertisement dated 18/6/2015, upon cancellation of the recruitment process so initiated, while the communication dated 27/7/2017 was again put up for recruitment by way of issuance of a fresh advertisement, and on conclusion of the recruitment process, the posts involved have already been filled up. So, in view of the above discussion, this court finds that the claim made by in the present not mandate an acceptance, and accordingly, the petition is held to be void of any, and consequently, the same stands dismissed. However, there would be no order. Yeah.
Deeply obliged.
Yes.
Well, receive the instruction, well, here, otherwise, well, the issue would be, well, though the so-called notice has reflected the rule 7, 1, and 3.
He will proceed in that direction only.
True, well, but the if your lordships find that the statement of allegation, the inquiry that is conducted.
Need to find, it's what you have, what is the show cause?
So cause notice is 7/1.
Him the notice. Let's see, we are proceeding against you under this. So he will do it in that manner. If you had left it only 7, then he could not have taken that plea.
Very true.
Now he does not know.
That's what I was thinking. I found it very interesting that 1(3) says about the punishment of minor penalty. The penalty which has been imposed is on major penalty. Now, my lord, here, by the so-cause notice, he was given an opportunity to respond to the statement of allegation. My lord, though the penalty that has been proposed was not there, but the inquiry was also conducted in that statement of allegation, where he got the opportunity to respond to the charges.
See, read rule 9.
Well,
Without prejudice, so and so, no order imposing on a government servant any of the penalties specified in Rule 7 shall be passed except after
an inquiry
held as far as maybe in manner hereinafter.
Provided.
Now, when you are framing a charge.
Charge. On the
you
basis of the allegation.
disclose
On the basis of the allegation on which inquiry is proposed to be
done.
held.
So, Kaushik,
Hello.
we'll have to look into Rule 9 once more and then
Hello.
reformulate your argument.
Hello.
Into Rule. I think there is an answer of what you are trying to.
Yes.
Because in our rules, the state rules, we don't have a distinction between like the CCS rule between major penalty charge sheet
There's not
and a
there.
minor penalty
Yes.
charge. So whether mere that protection therein would be enough, or if you go down the rules, bottom, if you go down, after conclusion of the inquiry, when the inquiry report is received, it is for the disciplinary authority to come to a conclusion as to whether 7 to 9 or something down and or 1 to 4 is imposed.
Yes.
See, there are two different procedures. There is one decision of our court. Is a decision. Got the, because Mr. Khan, only on the ground that you have asked to report that was prescribed there in 7.123.
1 to 3.
In the context of the rules, whether that would be fatal. That day I was with you, today new ideas have come up again. Because our rules, if you look at the rules, 9 procedure, come to after rule 9.7. After 9.7, major penalty, minor penalty.
Yes, major penalty and minor.
So it is at that stage that the division, whether it should be a major penalty or a minor
The
penalty,
satisfaction, this
is of the disciplinary authority.
satisfaction of the disciplinary authority.
Till that time, it's not there. In a CCS, the very initiation of proceeding is either for a minor penalty or for a major penalty. One proceed in our rules, it's only one proceeding. It can result in minor or major.
But otherwise, this is disproportionate because
that is a different argument.
well, that is the difference.
Let us get over with this. Interesting.
Yes.
And not examine this. Today morning I was thinking about it.
In fact, up till few minutes back, I was under an impression that it should go back and a de novo proceeding. But if your lordship finds the statement of allegation for which the
that will come later.
But
whether by you to satisfy that mere disclosing in the show cause.
no, I would say it misquotation of the
that is of no. So
that whether it would be fatal for the
some.
I'll try to.
There are lordship judgment. There may be a judgment lordship. That show cause may be issued in under major penalty, but can be punishment can be imposed in minor penalty.
But vice versa cannot.
Vice versa.
But Mr. Hunt, what you are trying to protect is of a rule wherein there are different provisions for minor penalty and major penalty proceedings. CCS rules. But here we don't have that.
Yes,
here are that bifurcation occasions only after 9.7.
Yes, but 9, 10, this is major penalties, and in 11, minor penalties.
So if you read that, just read that one line, the major penalty one line.
Yes. If the disciplinary having regard to its finding on the charges on the basis of the evidence adduced during the inquiry is of the opinion.
That stage, the disciplinary authority will have to decide whether he is going for a minor penalty or a major penalty. At that stage. Not at the stage of issuance of a
Lord, that could have lordship, whether the Shukos prescribed that the penalty which shall not be imposed under section 7(1) to 7(7). In that event, that discretion.
What your lordship
would
is
have come.
pointing out is this, Malak, they is of the opinion that any of the penalties specified has to be imposed.
Any of
That's
the
a-
penalties, that is 7(1) to 7(3).
no. Whether even in minor or in major,
Is both.
in both,
He will have
that
to
satisfaction has to be by the.
He will look into that. Then he will draw a satisfaction. These are all hypothetical things, but that will, for application of a law, you will have to have that grading.
Yes.
The channelization should be there. This is the channelization.
Lordship.
When a proceeding is initiated, without there being a differentiation between a minor and a major penalty proceeding, then the court will, then the disciplinary authority only at the end applies his mind.
After receiving the.
Now give me some material to take a contrary view.
But here.
I am with you. I'm not very satisfied with the manner in which this notices have been issued. But if that is of no consequence when you consider it in the context of the rules, more particularly 9.
And if it doesn't vitiates the otherwise the proceeding.
In 9(2), lordship, the disciplinary authority shall 9(2).
9(2) is after the opening paragraph.
Yes, after the opening paragraph.
In a show cause notice.
Definite charges.
No. In a show cause notice, after the opening paragraph, you have 9(2).
Lordship.
Right? And then you go 9(3), 9(4), 9(5), 9(7), I think is the inquiry report. 9(11), then these two things will happen. I'll give you another example. Here it is there somewhere. Say you have been alleged for charge A. But during the inquiry, another charge, misconduct, B, comes. Now, what to do? If you admit to that B, after being put to you, you admit, you don't oppose, then they can proceed, take it to be a charge framed against you and proceed. But if you don't, they'll have to issue you a fresh
show cause
or a supplementary charge. So, it's not that the authorities have the discretion to act beyond the rules. The rule prescribes for that. We'll hear.
But apart from that, lordship, can I draw another one aspect, lordship? If you lordship kindly the impugn order, there are two options is given. Punishment is given. It's 84. 85 is the relevant. Therefore, having agreed to the report of inquiry, I inflict the punishment of dismissal from service upon so and so teacher so and so with immediate effect. Next, the period which he remain absent shall not be treated as on duty for salary purpose or for pension purpose. Next is important. Kamaluddin Ahmed is turned discharged from service with immediate effect.
That is the beauty of your director. Can't help it. But your thing stopped with the first line, first penalty. Others are all the excitement of the director to ensure that you're put in a sealed thing, you can't come out. These things are of no use. But the learned counsel for the at some length. Hearing remains in con. When do you want it? We'll have it on 18th. May not be here for 2 days.
18.
Or if you want it before.
Before.
30. Pari? No, who does it? On 18/7 for father hearing.
18/8.
18/8.
Kindly explore.
Well, I'll also write.
I cannot get, I'll also do that, yeah. But Miss B. Chaudhary, Learned Senior Counsel, assisted by Miss so and so. Oh. Maras. Ibai Maras. Like Matini means. I dictated, I forgot. Your these two judgments are, will not have any application. That standing is only when arguing, otherwise.
Grateful.
Otherwise, it's your right to sit down. I find it very difficult when I was that side. I found it difficult when I was that side also. I find it difficult this side also. When I am dictating, when the judge was dictating, standing up. It's a distraction. I've heard the learned counsel for the parties and peruse the materials available on record. The petitioner on being found to be suitable for being enrolled as a member of the Assam Industrial Security Force, he was wide order dated 3/12/2008, absorbed in the said force subject to certain conditions that were imposed. One of the conditions imposed upon the petitioner relevant to the issue arising for determination in the present writ petition is that his such absorption was subject to successful completion of 6 months basic training. Also, the petitioner was thereafter deputed for undergoing training at the AISF battalion, 12th Assam Police Battalion on a police battalion. Full stop. The petitioner joined for undergoing his training in the said battalion on 1/11/2010. However, the materials brought on record reveal that the petitioner, with effect from 30/11/2010 to 13/12/2010, had remained absent from his such training without any intimation being given to the respondent, to the authorities of the said training center. The petitioner having been found to have remained unauthorizedly absent from his training, the commandant 12th Assam Police Battalion, wherein the petitioner was deputed for undergoing training, proceeded to discharge the petitioner from his training via a communication dated 13/12/2010. The petitioner having been discharged from the training, the petitioner is found to have not satisfied the conditions which would have led to his absorption as a member of the Assam's Industrial Security Force in terms of the order dated 3/12/2008. Also, the respondents of the battalion wherein the petitioner was so posted in pursuance to his to the order dated 3/12/2008, comma, proceeded to carry out a inquiry to ascertain the reasons as to why the petitioner had remained absent from his training. The inquiry as conducted in the matter had revealed that the petitioner had remained absent from his training inasmuch as he had found an ATM card of a colleague of his undergoing such treatment, and thereafter had misutilized the said ATM card for withdrawing money accordingly. The said act of the petitioner having been detected by the colleague of the petitioner, comma, the petitioner was not in a position to return back to his training camp. Accordingly, the petitioner remained unauthorizedly absent from his training. The reason why the petitioner having remained away from training coming on record has been noticed by this court, and this court finds that the said reason is not justifiable. The absence of the petitioner is not permissible to be condoned basing on the said reason which had required him to remain away from the training center. The disciplinary authority of the petitioner by an order dated 17/2/2011, noticing the discharge of the petitioner from his training by the Commandant 12th Assam Police Battalion, vide an order dated 13/12/2010, comma, proceeded to terminate the petitioner from his services on the ground that the petitioner could not complete 6 months of his basic training course. Although in the said order, it was recorded, it was highlighted that a due inquiry under provisions of that it was not expedient to hold an inquiry under clause 2 of article 311 of the comma, this court in the facts and circumstances of the case finds that such observation was out of context and was not mandated to be made. The said observation in the considered view of this court cannot be held to have invalidated the order dated 17/2/2011. The petitioner had also submitted an appeal. However, the appellate authority on a careful conclusion of the matter, on consideration of the matter, had wide order dated 6/1/2011, dismissed, rejected the said appeal, affirming the order passed by the disciplinary authority of the petitioner. The petitioner had thereafter approached the Assam Administrative Tribunal by way of instituting a appeal, being appeal case number 1180/2012. The Assam, the tribunal on the tribunal upon consideration of the matter was proceeded by order dated 10/9/2013 to reject the dismiss the said appeal and thereby uphold the termination effected in respect of the services of the petitioner. This court has perused the conclusions drawn by the tribunal in its judgment and order dated 10/9/2013 and finds that the tribunal had also held that the completion of the training was one of the mandatory conditions imposed with regard to the appointment of the petitioner. It also further held that the disciplinary authority had terminated the services of the petitioner by way of an innocuous order without casting any stigma on him. The inquiry that was initiated prior to issuance of the order dated 17/2/2011 was held by the tribunal to be only a only of a preliminary, to be only in the nature of conducting a preliminary inquiry, inasmuch as no conclusion was drawn by the disciplinary authority of the petitioner in the order dated 17/2/2011 with regard to any finding that may be recorded by the inquiry committee in its report. Also, it further held that the termination of the services of the petitioner, who at best can be considered to be a probationer, being in terms of the stipulations made in his order of appointment, would not mandate order of appointment, a regular disciplinary proceeding was not mandated to be held against the petitioner in the matter. Also, on a consideration of the conclusions drawn by the tribunal in the matter, this court is of the considered view that the same is not erroneous, and accordingly, the judgment and order dated 10/9/2013 would not mandate an interference. For the reasons, in view of the above discussions, this court is of the considered view that the judgment and order dated, considered view that the claim made by the petitioner in the present writ petition would not mandate an acceptance, and accordingly, the writ petition is held to be devoid of any merit, and the same, and consequently the same stands dismissed. However, there would be no order as to cause. I'm less sorry. You tried your best with the limited things you had at your disposal.
Much obliged.
Because being a legal aid counsel, you don't have access.
Yes, Lord.
We'll reserve it. It will not be possible. There is one more order I have to pass. Mr. Rafiq is waiting. Just pass that. This we'll pass it short.
Yes, obliged.
But Mr. Rafiq, who was opposing you and who is there with you, madam?
Kaushik.
Huh?
Vedanta Kaushik, sir.
Also heard Mr. B. Kaushik, standing, CGC appearing for the state, for the respondents. The petitioner in the present writ petition has presented a challenge to an order dated 2/7/2026 issued towards transferring and posting him from the zonal headquarter public NF Railway to Katihar New Jalpaiguri Katihar Railway Division. So, the petitioner in the present writ petition has projected that he was promoted to the post of assistant sub-inspector, comma, RPF, void an order dated 25/1/2025. Oh, sir. When you were posted, you were promoted, you were in Maligaon only.
Yes, Bill.
Oh, sir. It is further projected that prior to his consideration for promotion to the cadre of assistant sub-inspector, comma, RPF, the petitioner was posted to Maligaon. Mr. Just check the dates if something, facts and dates. Maligaon, void an order dated 12/3/2024 on spouse posting ground, in as much as his wife at the relevant point of time was serving at Maligaon in the Signal and Telecommunication Department of the Railways. Also, as the petitioner was continuing in his services as an ASI pursuant to his promotion at Maligaon, comma, the competent authority of the Railway Protection Force issued an order dated 11/6/2026, effecting transfers of the force members whose names have been included in the said order in terms of the SOP of transfer management module issued by the Railway Board wide letter dated 25/4/2006. It is projected in the order date. It is projected such transfer is projected to have been so done after the incumbents after the members of the force whose name had been included therein had completed their mandated tenure at the respective places of posting. They were so posted at the time of issuance of the said order dated 11/6/2026. The petitioner being aggrieved by the order by the transfer effected in his case by the order dated 11/6/2026 had approached this court by way of instituting a writ petition being WPC number 3188/2026. A coordinate bench of this court wide order dated 17/6/2026 while permitting the counsel appearing for the respondents therein, comma, to complete his instructions in the matter, and directed that the impugned order of transfer dated 11/6/2006, insofar as the petitioner is concerned, shall not be given effect to, comma, subject to the condition that the petitioner was not released as on that date. Also, thereafter, the said writ petition, along with other analogous matters, was listed on 24/6/2006. On the said date, the learned counsel for the petitioner submitted that he had instructions from the petitioner, that he had received instruction from the petitioner that the petitioner would approach the appropriate authority by filing a detailed representation. And further prayed that upon such representation be filed, the respondents be directed to consider and dispose of the same. So, basing on the submission made by the learned counsel for the petitioner, The coordinate bench wide order dated 24/6/2026 proceeded to dispose of the said petition by permitting the petitioners to file a detailed representation before the Principal Chief Security Commissioner, Northeast Frontier F2 Railway within a period of 3 days from the date of the order. Such a representation, if ipso filed, was directed to be disposed of by the said authority within a period of 7 days from the date of receipt of. The coordinate bench further protected the petitioner from being disturbed pending consideration of his presentation. The petitioner thereafter submitted a representation on 26/6/2026 before the Principal Chief Security Commissioner, RPF का report लिखी NF Railway. Also, a said representation on being considered was disposed of by the Principal Chief Security Commissioner, Maligaon, wide an order dated 2/7/2026, rejecting the prayer of the petitioner for withdrawal of the transfer as ordered in his case, wide the order dated 11/6/2026. Also, Saptara, being aggrieved, the petitioner instituted the present writ. Mr. I. Rafiq, learned counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that the order of transfer was so issued in respect of the petitioner in clear violation of the guidelines set out wide Directive number 58 bracketed revised. He submits that Directive number 58 lays down the procedure mandated to be followed by the respondent authorities for transfer of members of the force. It is projected that in terms of the provisions of Directive number 55, the transfer and posting of the members, annual transfer and posting of the members of the force is to be completed prior to
31st March.
31/3/2026. He submits that the completion period for completion of the process of transfer of the members of the force in terms of the said Directive number 55 is permissible to be extended for further 2 months by the Director General of the RPF. He submits that in the present case, the order of transfer was issued only on 11/6/2026, that is beyond the permitted time frame prescribed under the provisions of Directive number 58, and accordingly, the transfer as ordered against him being in violation of the provisions of Directive number 58, the same is void ab initio. Mr. Rafiq further submits that the Directive number 58 is so framed in exercise of the powers as provided under Railway Protection RPF, provided under Rule 28 of the Railway Protection Force Rules of 1987. Also, Mr. Rafiq next has further submitted that the wife of the petitioner is presently working in the Signal and Telecommunication Department, NF Railway, and is posted at its headquarters at Maligaon. Mr. Maligaon, and the petition was posted to Maligaon on spouse grounds only by an order dated 12/3/2024. Accordingly, he submits that the petitioner had not completed the mandated tenure at Maligaon after his such transfer on spouse grounds. That's your case? On spouse grounds. So, it is submitted by Mr. Rafiq that the petitioner is also saddled with the responsibility of providing necessary care and attention to his elderly mother as well as to his daughter, and accordingly, a transfer effected at this stage in respect of the petitioner would cause great inconvenience to his family members. Accordingly, he submits that there being vacant posts available in Maligaon and or at nearby stations surrounding at nearby locations, wherein nearby locations, the order of transfer of the petitioner was required to be modified and the petitioner posted at locations at Maligaon and or locations near to Maligaon, and thereby permit him to discharge his duties and at the same time provide for the necessary care and attention required by his family members. Anything more?
Nothing more.
So, in the above premises, Mr. Rafiq, by referring to the order dated 2/7/2026 issued by the Principal Chief Security Commissioner Maligaon, disposing of the petition of the representation of the petition terms of the authority granted by this court-wide order dated 24/6/2026 in WPC number 3188/2026 has submitted that the said authority, while proceeding to draw conclusions in the matter, had not considered the true purport of the directive of the procedure set out in the directive number 58. It is submitted that only by drawing a conclusion to the effect that the petitioner had served at Gauhati cluster since for over 22 years since his appointment in the year 1998, had proceeded to reject the claim of the petition. It is further projected that the respondent authorities had also, with regard to the spouse posting claimed by the petitioner, projected that the wife of the petitioner would be considered for a transfer and posting to New Jalpaiguri, to which place the petitioner has now been transferred, in the event a request is so made by the petitioner and or his wife in this connection. He submits that the said reasoning as recorded, the said reasons as recorded in the impugned order dated 2/7/20 would mandate an interference from this court. In the above premises, Mr. Rafiq submits that the impugned order dated 11/6/2026, insofar as it concerns the transfer of the petition, as well as the order dated 2/7/22, would mandate an interference from this court.
Only one line, my lord. In the order dated 2/7/2026, my lord, I have not been given any nearby station because the ground is that the petitioner has not specifically mentioned any nearby station office for posting. That is also a ground, my lord.
Okay. Something for your appeal I'm keeping.
Yes.
Mr. Per contra, Mr. B. Kaushik, learned counsel for the learned CGC appearing for the respondents, has submitted that Directive number 58 was issued by the Director General. By the Director General?
Yes. By the Director
Ministry of
General
Railway, Milord.
Director General, RPF, Railway Board. In terms of the provisions of Rule 28 of the RPF Rules 1987. He submits that such directives are mandated to be so issued relating to enforcement and furtherance of the provisions of the Act and rules as may be deemed necessary by the Director General of the Force. He submits that although in terms of the procedure set out in the Directive number 55 for transfer and posting of railway of enrolled members of the RPF, orders are mandated to be issued within 31/3/2026, and or within 2 months thereof, In the present case, he submits that the railway board had quite a communication dated 24/3/2026 required all units, all zonal railways, principal chief security commissioners, RPF, to initiate the process of transfer and conclude the same on or before 30/6/2006. 26. He submits that the said direction also having come from the railway board, the same would have to be read into the provisions of the Directive 58 and the time frame prescribed therein for issuance of transfer order insofar as the year 2026 is concerned, stood automatically extended till 30/3/2026.
Since the directives at page 28, my lord, will kindly see serial number J. The DGRPF reserves the right to withdraw and modify the.
So he further submits that in the Directive number 58, it has been provided that the guidelines issued thereunder was subject to being modified and or superseded by the DGRPF to meet administrative exigencies in future. Accordingly, he submits that the contention of the learned counsel for the petitioner that the order of transfer issued in his case accordingly, he submits that the contention of the learned counsel for the petitioner that the transfer effected in respect of the petitioner by the order dated 11/6/2026 being issued beyond the time frame prescribed in the guidelines formulated under Directive number 58, to be not acceptable. Mr. Kaushik has thereafter submitted that. Submits that the petitioner submits that it was found while processing the matter for the annual transfer that the petitioner had remained posted either in broken spells.
In continuous spells.
Has remained posted at Gauhati for over 22 years. Had posted in Gauhati cluster for over 22 years since in pursuance to his appointment, enrollment in the RPF in the year 1990. That is what his submission.
I was in Rongia also.
Oh.
5 years.
He submits that the petitioner was transferred from Rungia to NF Railway headquarters at Maligaon by an order dated 12/3/2024 on spouse ground. However, it was found that the said orders issued was in clear violation of the provisions of clause D.
D7, Roman 7.
Provisions of clause subclause 5, Roman 5, and 8, 7, subclause bracket of clause D of the said directive number 58. Accordingly, he submits that the transfer and posting of the petitioner to Katiha is in the administrative exigencies of the course, and the same is in terms of the procedure mandated to be followed in connection with the annual transfers of members of the force who have completed their respective tenures at the place of posting when such consideration of their transfer is undertaken. So, Mr. Kaushik, by referring to clause D, A of the order dated 2/7/2026 has submitted that the petitioner upon joining his transferred place of posting, has been granted the liberty to apply for premature transfer through TMM module once it becomes operational. Accordingly, Mr. Kaushik submits that the grievance of the petitioner would again be permissible to be considered by the respondent authorities after the TMM module is made operational and the petitioner submits a representation in this connection. Right? Anything more? So in the above premises, he submits that the transfer of the petitioner being a condition of his service.
One more point, my lord, if I may refer to, that the intent of this directives is that once the tenure is completed, ideally all the employees has to be given a transfer so that they get a chance. That is Roman 2.
At different places.
Yes. Roman.
Report likhiba. Order 2/7 or report likhiba. Mr. Kaushik has further submitted that one of the intentions behind issuance of the guidelines under directive number 58
D
is,
Roman 2. D Roman 2, page 70.
is to ensure that all enrolled members on completion of their normal tenure should be transferred in a way that everybody gets an opportunity to work in every sphere of the force. And accordingly, for the said purpose, ICT application named Transfer Management Module or TMM through apostrophe was designed and developed and made available to all competent authorities. Accordingly, he submits that the petitioner admittedly having completed his tenure, having remained at Gauhati beyond the permissible tenure, his transfer. The transfer as ordered in his case, the order dated 11/6/2026 would not mandate an interference. Would not in the above premises, Mr. Kaushik submits that the present writ petition would mandate to be dismissed in limine. I've heard the learned counsel for the parties and peruse the materials. Well, we have a meeting. You'll get the order on Monday. Anything?
May I submit these things, my lord?
What?
Is mentioned in the directive, my lord. It's paused from working.
So may this applies to your.
Yes, page 15, close 15, my lord. It is incorporated.
It is incorporated.
Yes.
What is
Transfer on
it is
top.
incorporated? Clause
Clause 15,
of
directive number 15.
page
Page 15,
page 50.
15, 15.
15. Clause number
Roman 15.
Roman 15.
Yes.
Page 15.
Page 15. Transfer of a member of the force considering the working location officer spouse as provided in the railway board's letter number so and so dated 2/2/2010. That's one.
That is definition.
No.
It is in the definition.
Oh, in the definition that has been incorporated there.
But not in the periodical transfer. The
I'm
the
talking about the
mechanism that
spouse
has
block.
been devised under the periodical transfer in the directives.
Okay, your wife can also follow you.
Yes. Subject to the condition, there is no vacancy nearby. In that case, my lord,
That they say that there are vacancies in Jalpaiguri. She can accompany you.
this guideline has come only to help the employees, my lord.
No, your wife will also require the same thing. She's also an employee. She also requires a spouse posting.
For the benefit of the employee, my
We
lord, the
will- we
railway
will-
board has
We
issued
will
this
make
guideline.
observation that.
Otherwise, I
They
would
are
say
breaking it, my
the
lord.
husband had shown 22 years
No,
love
I can
towards
go
the wife.
Bongaigaon,
The
my
wife
lord.
should
The wife
also,
has to.
wife should also follow.
I can go Bongaigaon.
Lordship,
I can
just
go here.
1 minute, item number 67, Lordship. I was not present when matter was called for, Lordship. One simple prayer, Lordship. I am for respondent number 7 and the next date is fixed for hearing, Lordship. So before that, Lordship, I would like to file affidavit in opposition.
We did not stop you. The matter is pending from 23. We did not stop you.
No, Lordship, I have filed wakalatnama on last occasion.
That is your headache. You file your counter. You file
In
your
between.
counter. Your counter.
Obliged,
You're that
Lordship.
interested, file it.
Obliged, Lordship.